We'll need to be efficient today. I thought yesterday we had some really great discussion, terrific questions, very helpful as we formulate policy for the state of Wyoming. And today will be no exception. We'll have a lot of important topics today. We're taking on our biggest bite of the interim, our review of Title VI penalties. For those listening, Title VI is our criminal code, and some of those penalties were set decades ago and have not really been reconsidered since. Others have been set more recently and created kind of a mosaic of different penalties for sometimes similar crimes. So the objective is to try to standardize a bit on that Title VI. So that's going to be our big bite of the day. Mr. Fuller, any words of wisdom, anything we need to be aware of?
Mr. Chairman, no prefatory remarks from me. Thank you.
Okay. Mr. Co-Chairman.
No, Mr. Chairman, I think you're doing an excellent job.
The day is young. All right. So we'll start with Title VI. Before we jump into the bill draft, we had two working groups. I'd like the chairman of those two groups to kind of give us an overview of the direction that your working group went, what some of your objectives were, without getting into all the details, but kind of give us a general overview of your working group and the end product. Start with Representative Chesty.
Thank you, Mr. Chairman. So I had an excellent working group that the chair appointed. I thought we had a great cross-section of representative interests. We had a number of prosecutors, we had defense counsel, we had law enforcement represented, we had judges represented. It was a very good, I thought, representative cross-section of people interested in this topic. I had to confess at the beginning of the meeting that I never practiced criminal law when I was in practice, so I was a little bit out of my element with all these the people who practice criminal law. But so that's why I relied very heavily on their expertise. And what we did, the approach we took was to identify some broad principles first, and then went through the individual crimes to see if they met the broad concept that we were trying to achieve. So there's 8 different basic, well, not 8 concepts necessarily, but why is this is not working? There we go. There's 8 topics I wanted to touch briefly on. The first thing I wanted to report was that we had some conversation at the beginning when the task force was created as to whether we should come up with some kind of a classification system. So we have, misdemeanor A, misdemeanor B, misdemeanor, first class felony, second class. And we talked about that at some length at our first meeting. And the consensus of the group was that there was no need for that, and that the current system worked fairly well. So there was no recommendation to create a classification system. We kind of have it a little bit. We just don't have names for the classes yet. And then we did want the flexibility to have some variation within classes. So we chose not to recommend any classification system. Second big principle was that for misdemeanors, so we took up misdemeanors first at one meeting, and then our next meeting we talked about the felonies. For the misdemeanors, there was a strong consensus that most judges don't really impose prison terms for misdemeanors. It's very rare for that to happen. So there was a consensus that we should reduce the penalties for most misdemeanors, not all, but most misdemeanors down to a maximum of 6 months in prison, or eliminate the prison term at all and make it a fine only kind of offense. So there's a group of recommendations that we have to take the maximum penalty for misdemeanors down to 6 months in most cases. There's still a few misdemeanors that we think are serious enough that do warrant a 1 year, but they're pretty rare. It's going to be pretty standard 6 month for most misdemeanors. And again, the odd chapters are dealing with property crimes. There may be different considerations when we get to group 2, where you have offenses against persons, where that principle might not apply. But for property crimes, we thought that a 6 month penalty for most of these property crimes was going to be sufficient. But then, which leads to the third concept, and the bill draft that we actually have in front of you today. There is a rule that says, a law that says the maximum probation that a judge can impose shall not exceed the maximum prison term. So when if we reduce the misdemeanors down to 6 months, that means the probation term is going to be reduced to 6 months, and the judges, actually the entire committee was of the opinion that creates, that reduces the flexibility of the court to impose an appropriate period of probation. Since probation is the primary way in which most of these courts are handling misdemeanors, we thought it made sense to basically write a whole new exception, and that's the bill draft that we have in front of you, to allow a probation term of up to a year for any misdemeanor, regardless of what the maximum prison term would be. So we have a group of recommendations that would then follow, would be increasing the probation, the possibility of probation up to a full year. And there's a group of those changes that we're proposing. And the concept here is we chose not to do a bill draft on all of these things. What we wanted to do was kind of come back to the committee and get your thoughts on our principles and the general concepts that we've come up with. And if there's consensus that these are good concepts, we want to implement them, we would come back in November with a full bill draft that does there's a lot of changes. It's going to be a very large bill with a lot of subparts, and rather than put LSO through that draft now without getting some buy-in first from the committee, we wanted to get the committee's input first. The next concept that we came up with was, if we're reducing the prison term down to 6 months for most of these misdemeanors, that the fine of $1,000 doesn't make a whole lot of sense. We want to reduce that to $750 in most cases. Again, not in every case, but in most cases, the fine would be reduced. So the basic, most of the misdemeanors would end up with a 6 month, $750, 6 month prison, $750 maximum penalty would be for the bulk of the misdemeanors relating to property crimes. Again, with some exceptions. We did go through each individual bill, a crime, and decided this one, there's a justification for the higher incarceration or the higher fines, and we left those alone. But in general, a lot of them are going to be reduced down to $750 under our recommendation. Getting to the felonies, we had, and this one was a little more controversial, but there was ultimately a consensus that in order to provide more flexibility to the courts and sentencing options, that most of the 2-year penalty, 2-year prison terms, 2-year felonies should be increased to 3 years. And that was not uniformly agreed to, but the consensus of the group was that we wanted to increase most 2-year felonies to 3-year felonies and increase the fine to $5,000. So what used to be a 2-year, $2,000 fine will now, under the recommendation, become a 3-year felony with a maximum fine of $5,000. And there's a group of changes that are listed in the report, starting on page 4, that cover all of those changes. And then there were some more serious felonies that had a 3-year, that were 3-year, $3,000 penalties. We want to increase those 3-year, again, make a 3-year felony would have a $5,000 penalty generally. So trying to reconcile that with when you increase from 2 to 3 and make it 5,000, we need all the 3-year felonies that only had a $3,000 fine needed to go up to 5,000 to be consistent with the other 3-year $5,000, 2-year $5,000 penalties. There are a couple of smaller, a small group at the bottom of page 5, bribery, compensation for past official behavior, soliciting unlawful compensation, bribery of an inspector. These are public official type of offenses that the group felt that the appropriate, the fine should be $10,000. These already carry a 10-year fine or 10-year maximum prison sentence. We thought that the fine should also go up to $10,000. And finally, there was a group of a couple of random ones listed on page, back to page 2 of the report. A couple of just one-off things that just didn't make sense to us as we went through it. These are minor things. So the offense of trespass on a closed or unsafe ski area, we wanted to reduce the maximum 5 down, or I'm sorry, amend it to be consistent with others, going from $100 up to $750 to be consistent with the other changes we were making. We wanted to remove, there was only one of our bills in our group that had a maximum, had a mandatory minimum, and that was the second offense of defrauding a drug or alcohol screen test had a maximum, had a mandatory minimum of 7 days. We decided and I think the other group also had concerns about mandatory minimums. We proposed to eliminate that mandatory minimum. And that last one, repeal the penalty for a second subsequent offense on trespassing unlawfully to collect resource data. We just suggested eliminating that second offense penalty, just eliminate the second offense and have the same penalty for the first offense. The idea here is that nobody thinks that this statute has ever been prosecuted anywhere in the state, primarily because it's been ruled unconstitutional by the Supreme Court. There are a few circumstances in which it might be constitutional, but generally it's unconstitutional according to the Wyoming Supreme Court. Nobody's ever prosecuted it. And just to clean it up, we thought we'd, at a minimum, get rid of the second subsequent offense. So that is the report, Mr. Chairman. I'd love to have a sense of the committee by the end of the day today as to if these broad principles are consistent with what the committee wants to go, the direction the committee wants to go, and if so, we can ask for a bill draft to make all these. There's many, many changes, but all of them would follow those basic principles.
Thank you for that excellent report. Committee, any questions, Senator Colby?
Yeah, thank you, Mr. Chairman. Just a general question on what was the logic involved with lowering the fine from 1,000 to 750? And I say that as an economic point of view when it comes to with inflation. And frankly, $1,000 isn't what $1,000 used to be, let alone lowering it to 750. I think if we're going to, I don't have an issue about the other lowering the time and getting those uniform, but I'm a little, I don't understand why it was chosen to go down and not up. Could I guess you help me with the conversation that might have been happening during that question?
Representative Shostak.
Thank you, Mr. Chairman. I guess we kind of took a look at the whole range of penalties and fines, and they were all over the place. We wanted to find a consistent middle ground for all of them. So we thought there are still a few 1-year, $1,000 misdemeanors, and if we're going to have a 6-month, we thought that the maximum penalty ought to be less than $1,000 because the jail sentence is less than less than a year. So we just picked 750 as kind of a compromise between the range that currently existed.
Follow up?
Yeah, thank you, Mr. Chairman. Specifically, though, about the inflation and basically the $1,000, but $1,000 isn't what it used to be. So keeping it at $1,000 or lowering it, and I just from an economic point of view with inflation and the devaluation of the dollar, that's so I guess that wasn't talked about then, what I hear. Thank you for the explanation, though. Thanks.
Representative, did municipal court have anything to do with picking the 756 months since that's their standard in municipal courts?
Mr. Chairman, I'm possibly, I can't remember that conversation. That's very possible.
Other questions for Representative Chestic?
Mr. Chairman.
Representative Singh?
Thank you, Mr. Chairman. I was a part of this working group, and as we walked through the different titles, Title VI, we wanted to weigh the value of creating opportunities for judicial independence, and so the first allowing the differences in parole specifically especially for like a first-time offender. I think there's a lot of value in allowing for the
Probation rather than parole?
Yes.
Okay, probation. All right.
Thank you. Mr. Chairman, just
This morning, yeah.
good morning. Yeah. The ability for our judicial system to evaluate each situation on its own merits, and for the people involved, these are we're not just talking about sentences, but individual circumstances for each situation that they may warrant different penalties, and I think this gives the discretion to the other branches of government to be able to reach out and really treat each situation on its own. And I support the work that we've done in this working group.
Well, thank you to the working group. Chairman did a great job. I looked at those spreadsheets and enormous amount of data to wade through, and you guys saved this committee a ton of time by doing the work of the working group. So thank you very much. With that, Mr. Fuller, who has the working draft on 117?
Yep, Mr. Chairman, I can go over that draft if
Would
you'd
you
like.
please?
Yep. So, Mr. Chairman, 27 LSO 117, this is draft 0.4. This is 9-02 in the online meeting materials. This bill draft would amend the maximum term of probation for misdemeanor offenses to 1 year. As Representative Chestic already noted, current law provides that the term of probation cannot exceed the greater of the maximum imprisonment term or 3 years. And the 3 years was work of this committee from around 7 years ago during the justice reinvestment process that the committee engaged in. So on page 2, lines 2 and 3, this is just a conforming amendment in 713-302B. And then page 2, line 14, a new subsection in this section would specify that unless otherwise expressly provided by statute, a court may impose a term of probation of 1 year for a misdemeanor offense. The staff comment just notes the reason why the unless otherwise expressly provided language is included is that specific offenses, for specific offenses, the legislature has determined that a different term of probation or a different maximum term of probation be available for those specific offenses. And the misdemeanor offenses in statute where the legislature has done this are listed on the top of page 3 in that staff comment. Some of these only provide up to 1 year of probation anyways. So this bill draft would, in a sense, render that language, duplicative perhaps. But in some situations, misdemeanor stalking, domestic assault, domestic battery, those offenses provide up to 3 years This bill draft would not change those maximum terms of probation. Then on page 3, line 28 and 713-305A is just a conforming amendment to reference that new subsection, and the bill would be effective July 1, 2027. With that, Mr. Chairman, I'd be happy to answer any questions.
Committee, any questions from Mr. Fuller? Representative Webb.
Thank you, Mr. Chairman. My question has to do with the $750 also. In your research, was you able to determine when that was first established at $750? Was it the 40s, the 50s, the 60s? Just curious.
Mr. Fuller, if
Yeah.
you know.
So Mr. Chairman, Representative Webb, I don't know specifically about the $750, but what I do know is the last, what I would call kind of major revision of Wyoming's criminal code took place in 1982 and 1983. I would have to do more research to determine if 750 was the fine set at that point.
I think my memory was certainly in 1980, it was 750, 6 months.
Mine too.
Other questions for Mr. Fuller?
I wish I could share in that memory, but that's not a possibility for me.
Mr. Chairman.
Senator Crum.
Thank you, Mr. Chairman. My question is, looking at this draft bill, I don't see the $750 in the bill. Where is it at?
Mr. Chairman. Yeah, Mr. Chairman,
Mr.
Senator
Fuller.
Crum, that question, I took it as unrelated to the bill draft. This bill draft only amends that the 1-year probation. It does not address any fines or the amount thereof.
Thank you.
So when we do a bill draft on the rest of Title VI, we can think about that. Senator Kolb.
Mr. Chairman, I found a Representative Webb ID tag, and I would like to know where Representative Webb is to give him back to him. Would you want to pass that down to Representative Webb?
Where's the Sergeant at Arms when you need him? All right, any further questions for Mr. Fuller? Okay. Any public comment on the bill draft before us? Anybody on Zoom?
And Mr. Chairman, I just ask if there is, I just ask they raise their hand on Zoom. Thank you.
Yes, if you're on Zoom, please raise your hand if you want to testify with regards to Bill Draft 117
We
on
have,
probation for misdemeanor.
Mr. Chairman, we have Marav Ben David.
Can you bring him in?
Yep.
Good morning. Please tell us what you want us to know about Bill Draft 117.
Hello, I'm Rav Ben David from Laramie, Wyoming, and I am on the board of the Wyoming Coalition for Animal Protection. And I have emailed some materials to you. Unfortunately, I think a little late. But I would like to talk about the fact that animal cruelty penalties are coming under the odd number. And there is a bit of a problem with that. So basically, we know from a lot of research that there is a strong connection between child abuse and domestic violence and animal cruelty cases. Just to give you a quick example, in 1983, a survey found that child abuse cases also included in 88% of the cases animal cruelty. And in 97, they found that people who committed animal cruelty also committed felonies against other humans. 43% of people involved in school shootings also had convictions of abuse of dogs and cats. And if you do a quick search online, you'll find many, many more. So I think that the penalties as and the scales of misdemeanor and felony under the Title VI, Section 3 do not match the severity of and the potential cross criminal activity between animal cruelty and child abuse or domestic violence. I did create a table to help because I know that each of the committees did one odd numbers and one even numbers. So I created a table comparing the two. And I would like the committee as a whole to look at the potential changes that I hope my colleague, the chair of the Wyoming Coalition for Animal Protection, will be presenting to you soon. She's driving from Laramie to Casper. So again, thank you for the opportunity to speak in front of you. And I would like you to consider the information we're providing regarding the differences between the odd and even number rules when it comes to animal cruelty cases.
Thank you, Ms. Ben David. Appreciate you being here. I know it gets a little confusing as we're dealing with all these topics at once. This bill draft is specific to probation for misdemeanor crimes. So it's a little bit distinct from the animal cruelty penalties. But when the committee takes up Title VI as a whole, we appreciate your comments and we'll keep those in mind.
Thank you very much. I really appreciate the opportunity to speak in front of you.
Thank you. Appreciate you being here. Any questions for Mrs. Ben David? Okay, thank you very much. Anyone else on Zoom?
Nope.
Anyone else in the room relative to misdemeanor probation? Mr. Shannon?
Mr. Chairman, Co-Chairman Olson, and committee members, I'm Dan Shannon with the Department of Corrections. I just have a brief comment just from information that may assist this committee. Regarding Representative Chestik's information on misdemeanor probation, if it's 1 year or it follows within our statute. From August 1st, 2021 through August 1st, 2026. So for the past 5 years, the Department of Corrections has supervised 2,710 misdemeanors cases that exceeded 1 year or.
Can you say that number again?
From August 1st, 2021 through 26, for a 5-year period, we supervised 2,710 misdemeanor cases of 1 year or more of supervision. The primary driver was obviously was our DUI with 1,100 cases. Mr. Farmer spoke about other cases that are permit up to 3 years: domestic violence, domestic battery, assault, misdemeanor stalking. We had 65 cases of battery and 1 of voyeurism. So I think the bottom line to take away the report out to the committee, 57% of the cases we supervise fall within the 1 year and 43% exceeded beyond what the statutory provisions provide.
So, Mr. Shannon, do you perceive this bill draft as having a direct impact on your workload for your field services personnel?
Mr. Chairman, committee, no, we will adjust to either. I don't really have a horse in a race. We'll adjust to whatever the committee and the legislative body does. And I don't see a negative impact on it, no.
Committee questions for Director Shannon?
Thank you.
Thank you. Useful information. Anyone else in the room relative to misdemeanor probation? Mr. Itzen? Always good to have our Natrona County DA join us. Good morning. Make sure your green light's on and state your name for the record.
Thank you. Morning, my name's Dan Itz and I am the district attorney here in Natrona County. I think when we start talking about changing Title VI, and specifically when we started talking about fines with respect to misdemeanors, I believe Senator Cole kind of hit it on the head. In a large degree, it seems like we're potentially going backwards here. A number of years ago, this body decided theft, a property crime, if it's committed 5 times, becomes a felony. We're moving forward. This committee last year or 2 years ago decided unauthorized use of a motor vehicle was no longer appropriate because of values. We no longer have that. We're moving forward. It seems today what we're doing with reducing fines is taking a step backwards from where we've been and where we want to go. Things aren't always as cheap as they once were. And that's absolutely the truth of the matter. When we start talking about the idea of reducing penalties, that should give us pause. I think it takes away some level of discretion, not only from the prosecutor's office and what offers that can be made, but the judicial branch as well. Essentially, we've lowered the ceiling on things. And instead of having a 2-story building, we're going to have a 1-story building now. And that seems very counterproductive to where we've been and where we want to go as a state when it comes to the property crimes. The idea of moving misdemeanors to a 1-year term of supervision, I think that's probably an appropriate idea. Director Shannon's right. And Internal County puts misdemeanor folks on probation, on supervised probation. There are certain people within our society that need to be watched. That's just a matter of the fact. They can be misdemeanors or they can be felons. But they need to be checked up on. I always get somewhat queasy, I don't know if that's the right term, when we withdraw mandatory minimums. Now, the truth is, under Robinson versus State, Wyoming really does not have a mandatory minimum. The court can impose it, then suspend it. They just have to impose the entire mandatory minimum and suspend it. And that's happened in several cases. So the idea that we're taking away the 7 days or whatever your mandatory minimum is, in theory, the court can do that anyway. Do they do it in every case? Absolutely not. But that's there. But it's also a pushback position. Judges can look at that and know what the legislators meant, right? That, hey, this is serious. If you're doing it twice, maybe 7 days is appropriate. Those are the things that I see potentially coming up that cause some concern or some issues. I don't think we need to take a step backwards and lower fines. That just makes no sense to me. I understand the probation part and leave the mandatory minimums where they're at. If a judge wants to suspend that for whatever reason, they can do that now. I'd be happy to stand for questions.
Questions? Representative Kelly.
Thank you, Mr. Chairman. When we're talking about lowering the fines, what do you think about the concept that they've already been lowered, that it's already gone down 25% when we account for inflation for the last 5 years? Is there room possibly to increase them to at least keep in line with what their intent was when the law was originally passed?
Mr. Ritson.
Mr. Chairman, Representative Kelly, thank you for the question. I agree with that. I think I see it as a little different point. I'm trying to change somebody's behavior. And if I can do that by fining you and you're like, I will never do that again, great. But the truth is, if we continue, DUI is a pretty good example of imposing a $500 fine every single time. I'm not changing anybody's behavior. I'm still living in that 1-story building. If you get a DUI or a theft crime, the first time I say, Representative Kelly, your fine's $300. Representative Kelly, second time your fine's $500. It's $750. Well, then you just think, okay, I'm maxed out. He can't do any worse to me than the $750. And Sometimes people make more money and you talk about inflation, you start talking about doing those things. Yeah. As I talked about yesterday, I think part of all our jobs is to protect the public. But it's also to keep up with the times. And I think that this is kind of taking a step back from that, sir.
Mr. Ritson,
Yes, sir.
how frequently are maximum fines imposed?
It's probably infrequent. I'm sorry, Mr. Chairman. It's probably infrequent. I can't give you an exact number when they're imposed. You will see that with repeated behavior, however, or something that is so grossly disproportionate. It may be your first time, but you really hit it out of the park. And that's when we need the higher fines.
Thank you. Appreciate your comments.
Yes, sir. Thank you.
Anyone else on the bill draft? Seeing none, I'm going to close public comment on working draft 27 LSO 0117. Committee, what's your pleasure?
Move the bill.
Moved by Representative Shestak, second by Co-Chairman Olson. Amendments. Any amendments? Saying none, discussion?
Mr. Chairman.
Representative Singh.
Thank you, Mr. Chairman. Yeah, just with the time that we spent on in the working group, the intention was really to make sure that the punishment fit the crime. And in some of these cases, specifically when it came to the dollar amount at the end of the day, I mean, the value of currency changes, and we see that all the time. And frankly, it's a crime against the people that it changes so much. But we're looking at the actual implications of how the person that the purpose of our justice system, I would say fundamentally, is not necessarily to punish individuals for doing wrong, but to guide them to doing what is right. And we should not, I think it would be a wrongdoing for us to use the power of government to inflict more damage than what is already done. Though the value of the dollar goes down at the end of the day because of powers that we don't have influence over, I don't think that the buying power of the average individual, the standard citizen whom we represent, should necessarily go up and be more of a crushing blow in proportion to the actual value of their dollar too. And so to give it merit and to have the conversation about whether the courts are able to have the discretion to impose the fines that are necessary, I would advocate that we err towards the side of the citizen. And so, thank you.
Mr. Chairman.
Thank you. So
Mr.
this working draft only deals with
Probation.
the probation. And so let's keep our comments focused on that. My intention, just so it's clear for the committee, is after we hear Representative Lean's report on the other working group, then we can take up recommendations for bill drafts to address further changes to Title VI. So any other comments relative to 117, Co-Chairman?
No, you covered what I was going to cover. The bill's about probation, not about fines. So.
Okay. Anything else? Senator Cole.
Yeah, thank you, Mr. Chairman. I want to support this the way it is, but I have great hesitation in diminishing the discretion of the courts. That's my issue with making these type of changes. I haven't heard anything that said the court system's not working correctly. Quite the contrary, all the testimony has been that the courts typically consider a range consequences for doing some act. But I just wanted to make those statements, Mr. Chairman.
Senator Craigle.
Yeah, thank you, Mr. Chairman. I guess just for everybody that's listening out there and everybody in the room, I just think we should, for purposes of discussion, point out, I actually think this bill gives more discretion to the court and more discretion to our prosecutors and to the defense bar as well. I mean, it allows them a wider range of solutions to any particular case. And so I think we're actually doing the entire justice system, doing them a service by trying to create an additional option. So I think it does more, creates more options, not less. Just want to point that out. So if anybody's watching, they kind of know what's going on. Thank you, Mr. Chairman.
Mr. Chairman.
Mr. Vice Chair, Co-Chairman.
Thank you, Mr. Co-Chairman. I think because of the way the testimony unfolded today and, coupling it with the report from Representative Chestek, I think there's confusion right now amongst the committee on what is actually before us. What is in front of us is a bill draft that moves probation for misdemeanors from a maximum of 6 months to a maximum of, for all offenses, to a maximum of 1 year. So it provides greater flexibility for judges and prosecutors to work within a 1 year period for all misdemeanor offenses for probation. Although we talked about fines going from 1,000 to 750, that's not part of this bill. Just want to make sure, agree with Senator Craigle, the public needs to know what we're talking about, but also I was a little concerned the committee got a little lost with all the added stuff that we talked about and some of the testimony that we had that wasn't exactly on point, I think led some of us astray, but just want to refocus us back to the bill, Mr. Co-Chairman.
Thank you. And the bill draft, just so we're clear, still retains the longer periods of probation for domestic violence and those other offenses. So that's still retained. We're just dealing with the 6 months, extending probation to up to a year, even if the maximum jail sentence is 6 months incarceration. So with that, I'm sensing an urge to vote. Question being called. All those in favor of roll call vote, please, on 117.
This is a roll call vote to sponsor 27 LSO 117. Senator Craigle.
Aye.
Senator Crum.
Aye.
Senator Hicks.
Excused.
Senator Cole.
Aye.
Representative Brady.
Aye.
Representative Bratton.
Aye.
Representative Chestek.
Aye.
Representative Feiler.
Aye.
Representative Kelly.
Aye.
Representative Lean.
Aye.
Representative Singh.
Aye.
Representative Webb.
Aye.
Co-Chairman Olson.
Aye.
Chairman Washik.
Aye.
Thirteen ayes, one excused.
So with that, 117 will be a judiciary bill for the next session.
And Mr. Co-Chairman, just for Representative Bratton, I think we have to have Representative Bratton on screen when she casts her vote. It can't just be a voice vote. I believe that's in the Management Council manual. So Representative Bratton, if you're hearing me, when you do cast your next vote, if it's a roll call vote, make sure you light up yeah, there you go.
There she is.
Thanks.
Good morning. All right. Let's now move to the Title VI Working Group Even chapters for their report. Representative Lean.
Thank you, Mr. Chairman. And I'd just like to thank the group of people that put together this working group, from our LSO staff to our police officers, to our chief of police. We had judges and attorneys and our victim advocates. They did a great job, and they sacrificed their lunch hours for me on 3 occasions. So I'm grateful for the opportunity that we had to get together and to visit with that. In this even group, these are crimes against persons, offenses against persons, and we took the opportunity to also discuss whether we wanted a classification or a graduation system, and this working group did not consider an adoption of either of those. So much like the odd group, we'll stick with that consensus for the committee recommendation. There were a few recommendations that we had moving forward, and I'm just going to kind of summarize them. I hope that you've had a chance to read through this memo from LSO. I will preface this with I did miss the first working group. I had a medical emergency within my family to deal with, and so I'm grateful for Chairman Brady, who stepped in for me to be able to lead that, and I'm grateful for Mr. Fuller, who assisted her along the way. Mr. Fuller made all of these meetings, as well as Ms. Nord, and I appreciate their opportunity to provide this for the working group. So if they chime in, that's because I wasn't there and they're filling in a few details for me. The first one that we'd like to start with is first degree murder, to take that from life imprisonment to life according to the law. And that would specify that a life sentence would be commuted to a term of years, after which a person would be eligible for parole. The next one would be to remove mandatory minimum sentencing while leaving the maximum sentences unchanged. The thought process behind removing the minimum sentencing is that this gives the opportunity for our justice system to work on a case-by-case instance. And there's a list of statutes here that would be affected, and that would be kidnapping, first-degree sexual assault, second-degree sexual assault, more sexual assaults, let's see, sexual abuse of a minor, aggravated robbery, blackmail, assault and battery with genital mutilation, human trafficking, first and second degree, subsequent human trafficking, sexual exploitation of children. And then we move on to removing the look back period. To remove the look back period, let me just review here. Removing the look back period was a concern for offenders who engage in domestic violence habitually and not within the 5 or 10-year permitted look back period. There is also discussion about offenses and thresholds, theft, drug possessions, for those type of look backs. And this one was discussed in the meeting. I was not there, so if Mr. Fuller has anything to add.
There we go.
Mr. Fuller.
Yeah, Mr. Chairman, for the subsequent offenses of domestic battery, the concern that the working group discussed that was raised was a habitual offender, once those offenses dropped off, would not be subject to greater judicial intervention because of that limited look back period. So that was the tenor of the discussion for those two recommendations.
Thank you, Mr. Fuller.
Thank you.
For violations of domestic violence protection orders, this group has identified to include language that authorizes a term of probation for up to 1 year and clarify that the offense may be committed even if the order is issued, and tying it 64404 with 3521-104, 3521-105. And then we move on to forced labor or servitude. There is also a LSO about recklessly, and we'll have that conversation, I'm sure, sometime this morning. With this working group, we discussed recklessly quite a bit, and we feel that it would be to delete recklessly still allows for implementation of the law, but that generally if there's forced labor or servitude, it's not done in a reckless manner. And then we moved on to sexually related offenses. To have a maximum imprisonment penalty for subsequent offenses, to double the maximum imprisonment penalty for the first offense. And this recommendation would affect repeat offenders of the first and second degree sexual assault, third degree sexual assault, repeat human trafficking, unlawful distribution of non-consensual sexual or synthetic sexual material. For the offense of soliciting to engage, soliciting to engage in illicit sexual relations, this would increase the maximum from 5 years to 15 years. And this was just to bring consistency across the statute, as well as increasing the first offense for sexual servitude to 15 years, the first offense for sexual servitude with a minor from 5 to 25 years, the first offense of sexual exploitation of children to increase this from 12 to 15 years, and the second subsequent offense from 12 to 30 years. These changes are just to create uniformity across the code of individuals that are harmed in a sexual manner. The working group discussed recklessly, and it's defined generally in Title 104 AIX. The working group asked for research on this, and thus you have the memo from Mr. Fuller. And that concludes what we worked on in the even working group.
Committee, any questions for Representative Lane? Thank you for your great work on the work.
Mr. Chairman.
Senator Kolb.
Yeah, thank you, Mr.
Hey, let's go to Mr. Fuller first and then we'll grab you.
Yep, my apologies, Mr. Chairman. I was just going to add maybe a few additional points of information to perhaps aid the committee. So for the recommendation concerning the language for the first-degree murder penalty, that language provides for 3 options for a sentence: death, life imprisonment without parole, and then the term that is used is life imprisonment according to the law. And the concern that was raised by the working group with that particular recommendation was that life imprisonment according to law. And the question I think that was raised by members of that working group is that language could arguably connote eligibility for parole, when the reality is a person sentenced to life imprisonment according to the law is only eligible for parole upon the commutation of that sentence by the governor to a term of years. And so the working group's recommendation there was to delete the phrase according to law and reference a statute, 610-301C, which outlines that commutation must take place before a person is parole eligible. So that was the genesis of that recommendation. For the recommendation for mandatory minimum sentences, there was not unanimity among the working group of that, particularly as it pertained to the mandatory minimum sentences for first-degree murder, which is life imprisonment, and second-degree murder, which has a minimum of 20 years. Mr. Chairman, there was another recommendation for the offense of breach of peace in 66102A. The working group discussed removing the reference to violent actions from the actions that would result in a person committing that offense. The genesis of that recommendation and the discussion of the working group was that because that term references violent actions, that could implicate federal law for firearm possession and could result in ineligibility for a person committing breach of peace to be eligible from possessing a firearm under federal law. Then, Mr. Chairman, I would just note the discussion for having the maximum imprisonment penalty for certain sexual related offenses be double the maximum for the first offense. The working group did not necessarily discuss individual offenses, but just discuss those specific offenses broadly, as a concept. And then finally, Mr. Chairman, the focus for increasing some of the maximums that are listed on the bottom of page 3 and the top of page 4, the genesis of that discussion was to align primarily penalties involving exploitation or servitude to have those align with Wyoming's other sexual related offenses. And with that, Mr. Chairman, happy to answer any questions as well.
Questions for Mr. Fuller? Helpful very much. Thank you. Senator Kolb.
Yeah, thank you, Mr. Chairman. I guess I'd like to know a little bit more about why they chose to decrease from life to 100 years, which I'm confused on why 100 years isn't life and why that choice was made. Why wasn't life good enough when 100 years is past?
Mr. Fuller, sensing and awareness of the answer?
Yep. So Mr. Chairman, Senator Kolb, the committee, the working group did not expressly discuss those 2 specific offenses. I think the discussion focused primarily on making for generally for the sexual related offenses, have the subsequent penalty be double the first penalty. They did not discuss particularly that repeat first degree or second degree sexual assault or the repeat human trafficking. They did not specifically discuss those already having life sentences.
Senator Gold, did I answer your question?
Oh, kind of. It's our good attorney, Mr. Fuller, did his best, but no, I still, I see it written here, and I don't see the difference why we had to change the language from life to 100 years. That was really my question. Thanks,
Mr. Cody.
Representative Lean?
Thank you, Mr. Chairman. For the good senator, we just discussed the opportunity to double the maximum penalty, and that pushed it from 50 years to 100 years. And so life and like Mr. Fuller addressed, we didn't discuss the life imprisonment itself. It was merely the double the penalty.
Thank you. Representative Kelly.
Thank you, Mr. Chairman. I'm sorry, committee, I'm going to need a little bit of an explanation for the impetus of wanting to remove these mandatory minimums. Rape, child rape, sex trafficking, the worst of the worst crimes, genital mutilation. Why would we want to offer the opportunity for somebody convicted of such heinous crimes to get off more easily? I'm not understanding the reasoning.
Representative Lane?
Thank you, Mr. Chairman. And I am not recalling the conversation on that. I don't know if there's someone else that was involved in the committee that could speak to it.
Mr. Fuller?
Yep, Mr. Chairman, Representative Kelly, I'm not sure I have much to offer in that regard. There was members of that working group who raised that. As I mentioned, there was not unanimity among the group. There perhaps was a consensus to make that recommendation. Obviously, Mr. Chairman, Representative Kelly, every single bullet point on both of these, these memos, these recommendations are just at the recommendations, and the committee can pick and choose what it would like to, how it would like to proceed if a bill draft is indeed requested.
Representative Lean, was there a general opposition within the working group to mandatory minimums as a sentencing philosophy?
Mr. Chairman, I don't recall that there was a stout conversation on mandatory minimums in opposition, no.
Representative Chestic.
Thank you, Mr. Chairman. And in the working group for the odd chapters, we also had a conversation about mandatory minimums. We only had one crime in our group that had a mandatory minimum. It was a 7-day mandatory minimum. And we agreed to eliminate that. But I do recall the conversation was that, especially for the judges, they wanted some flexibility. Mandatory minimums deprive the court of some discretion. And there was, I think there was a pretty clear consensus among everybody represented in our group, prosecutors, defense counsel, judges, that giving courts flexibility and discretion is a good thing, and we wanted to preserve the discretion of the courts in sentencing decisions, and therefore there was kind of a generalized opposition to any kind of mandatory minimums. That was the discussion that we had in our group. I would assume that similar conversations happened in the other group because the same groups were represented in both of the working groups.
Representative Kelly, you good?
Mr. Chairman, I'd just like to make a comment that as somebody who's taught history and political science for decades, I understand the impetus for mandatory minimums, and it was general public outrage that people convicted of crimes were getting off ultimately scot-free, often because their connections, their money, their attorneys. So I understand the philosophy, and I appreciate the idea of judicial discretion. But this was a public outcry, particularly if you go back to the 90s, and the crime rate was much higher than it is now. So I'm very reluctant to go back to the laws that led to some of the highest crime rates in American history.
Okay. Further comments or questions, Representative Lee? Okay, thank you for the report. Thank you to the LSO staff for compiling both of these reports. Committee, we've been at it for an hour now. I want to take about 10 minutes before we open up for public comment. We'll come back at 9:40 and continue this discussion. All right, committee, will you come back, please? So what we're going to do is we're going to take public testimony generally about anything and everything that you've heard regarding Title VI this morning, other than the bill draft that we've already approved. Get all that on record so we get to hear where everybody's thinking about things. And then we're going to have the committee work the recommendations in small packages. So we might look at just the misdemeanor crimes. And then we might look at mandatory minimum discussion. So we're trying to bundle these things up for our discussion up here, but for public comment, we'll just hear testimony from anyone and everyone who wants to chime in on our thoughts about Title VI. Okay? Representative Lee?
Thank you, Mr. Chairman. For the public's edification, could we have Mr. Fuller review his reckless memo?
Mr. Fuller, please.
Yeah, so Mr. Chairman, one of the topics that the even chapter working group discussed was concern, and Mr. Chairman, the committee heard some of this discussion yesterday in the discussion on the homicide by vehicle and the statutory definition of recklessly. The even chapter working group identified every instance, I believe not only in Title VI, but I think throughout Wyoming statute, of the use of the term recklessly when it came to criminal law. And there was a request for a little more information on how other states define reckless for their criminal statutes. And so I was able to research at least the states in the 10th Circuit, of which Wyoming is part, for their definitions of reckless. So that memorandum is included in your materials. It was handed out separately as well at your desks yesterday. Many years ago, mid 20th century, a model penal code was developed in an attempt to bring more consistency and uniformity to the criminal laws of the states. And in that act was a definition of recklessly. And so that's on the top of the first page. And Mr. Chairman, my research showed most states have either, they base that definition from the model penal code, or their definition is some variation of that concept. The concept of a person undertakes, it consciously disregards a substantial and unjustifiable risk. That's what Wyoming's definition includes in 61104. And that, at least among the 10th Circuit states, appears to be the case as well. Oklahoma, I could not find a definition of reckless, but their Court of Criminal Appeals, which is their highest court dealing with criminal matters, said that reckless disregard is precisely the same as their state's definition of culpable negligence, and I included that definition. So that was kind of the one outlier that I could find among the 10th Circuit states. In the even group's recommendation were, as previously noted, some recommendations to for some of the offenses, remove recklessly as a mental state for the commission of those offenses. With that, Mr. Chairman, happy to try to answer questions on this.
Questions regarding reckless? Thank you. All right, with that, we'll open public comment. Anyone wishing to chime in on any of these topics from either of the two reports on Title VI review by the working groups? Any state, we'll start with state agencies. Are there any state agencies that want to participate in this discussion? Good morning. Please make sure your light turns green and introduce yourself for the record and tell us what you want us to hear.
I suppose I wasn't pushing it hard enough. Patty Bennett, I'm the state public defender. Mr. Chairman, I was part of both of those working groups, as was Mr. Corman. I'd also like to introduce David Corman. He is the Deputy State Public Defender. And I don't have specific comments other than on the first-degree murder. I can speak to that just a little bit. But the overarching, I guess, theme or desire on all of these changes that these working groups were trying to make is not to make anything easier, not to make punishments easier, but really to do two things. One was to give some consistency among the statutes. Some, were 6 months, some were a year. And so on the misdemeanors especially, but on the others as well, the idea was to have some consistency among the penalties on both of these working groups. The other, I think, idea was that we wanted to be able to give judges, prosecutors, and defense counsel more ability to look at cases and to look at defendants individually and to be able to craft solutions, plea agreements, sentencings that were appropriate for the specific person in the specific crime. So that was the idea, would be to be able to give the people that are actually involved in these cases, and especially our judges, the opportunity to be able to craft sentencings that were specific to the cases. And that was when the discussion about mandatory minimums came in. I don't have a specific position on whether that is a good thing or a bad thing, other than when we start removing some of those parameters, it gives the opportunity for the participants to be able to craft solutions that are more consistent. With regard to specifically the first-degree murder, just removing the life according to the law, and rather than that language, to be able to refer to the statute that specifically lays out exactly what the three options are. Life according to the law can be, it sounds very grand, but it is a little bit confusing as to what exactly that means. So all that does is remove that phrase and refer to the statute that spells it out. So it doesn't decrease any penalty. It doesn't do anything other than just clarify the language.
Thank you. Mr. Corman, do you have something more?
Mr. Chairman, no, I have nothing additional. Thank you.
Okay. Committee, any questions? Ms. Bennett, you heard probably District Attorney Itzen comment about mandatory minimums being waived, and then the court, they impose them and then waive them. Is that your experience as well? What's the practical impact in Wyoming of having mandatory minimums in our statutes?
Representative Washington, Mr. Chairman, I have not personally experienced that in my, more than a decade of practice, especially on the more serious crimes that I think Representative Kelly was concerned about. Anecdotally, I've never had a judge give someone probation on a serious crime that has a mandatory minimum. I don't see that happening. On the other side of that, on some of our more minor crimes, sometimes on these 7 days or 30 days in jail, I think that the committee should really consider, when someone qualifies for my services, they are pretty much impoverished. And if someone has to serve 30 days in jail, to us, it's like, okay, well, you serve 30 days in jail. You did this crime. You should go to jail for 30 days. 30 days in jail for some people, which is a lot of my clients, means they lose their job, which is probably a low-paying job. They lose their home. And when they lose their home, they lose a lot of their possessions very often. 30 days in jail means a lot more to some people than it means to others. And so the ability, the removal of those, especially those lower ones, really gives the court and the attorneys the opportunity to look at the individual person. And so I think that it's important to consider. I understand that driving under suspension is frustrating. It can be dangerous. There's a reason that person's license is suspended. But a misdemeanor offense was never intended to completely destroy everything in somebody's life. So what, it gives the opportunity for that judge to say, okay, was this person just out with a complete disregard for the law? Or does this person have 4 kids and they have to work across town and they're trying to work and feed their family? It gives the courts the opportunity to make that decision based on that person's specific situation, rather than just say, okay, well, it says 30 days, you're going to jail for 30 days and there's nothing I can do about it.
Okay, thank you for that insight. Any further questions? Appreciate you being here this morning.
Thank you.
Any other state agencies want to testify about Title VI? Any state agencies on Zoom? All right. Yes. Okay. Ms. Hackle, bring her in, please. Good morning again.
Good morning. Did I show up on camera? Mr.
For a
Chairman?
minute, and then you disappeared. Like we have
My
to-
intent exactly. I'm not sure. Okay, hold on. Let me click another button. There we are.
Now you're back.
Thank you, Mr. Chairman. My apologies for the technological glitch. My name is Sylvia Hackle. I'm the District Attorney for Laramie County. In that capacity, I served on the even number working group. I was present yesterday for your discussion of the vehicular homicide bill. And Loretta Callis did most of the talking on behalf of the County and Prosecuting Attorneys Association. I do not know if she is present today to represent the association's position on the odd and the even working groups. From my participation in the even working group, which was, I think, we had some really robust discussion. Thank you to our chairman and to those who assisted in the group. I would agree with much of what both Dan Itzen said earlier today and what Ms. Bennett just said. I personally think that mandatory minimums have a role for the more serious felony offenses. Or the repeat offenses. I don't know that they have that much of a role in the misdemeanor world. And I do have one experience, but only one, in my 46 years of practicing law, of an individual charged with aggravated robbery, which has a 5-year minimum. He was 16 years old. He was charged as an adult, and I worked out with the prosecutor a recommendation for what's called 301 first offender sentencing. So he was allowed to plead to regular robbery, not the enhanced aggravated, and he got probation for 5 years. It was a very unique set of circumstances. I've never seen that again. Not that I've seen every case in Wyoming, but I've seen a lot. So while I think judges can drop below the minimum, I think they don't, because what I think a minimum sentence does, particularly on the felonies, is it conveys the legislative intent on behalf of the people of the state of Wyoming that this is serious and should be sentenced accordingly. Now, should those minimums maybe be considered by this committee? I don't disagree with that. There are a couple places they seem inconsistent. But that would be my comment about pretty much the overall minimums. And otherwise, we did talk about recklessly. It does seem to be dropped into the statute. It's sort of peppered throughout. I did some research, which was then passed on to the even working group, and the word reckless shows up a lot. And perhaps we should be more careful in our use. And that we should make sure that we use the consistent definition as set forth in the statute. Beyond that, I will stand for any questions. Thank you very much.
Questions for Ms. Hackle? Appreciate your insight. I guess I'm wondering, are there places in our statutes that can be easily identified where recklessly seems inappropriate or dispensable, and other places where it seems necessary. Can we identify those?
I will pull up and look at the list I made. And if you would like, I can respond to you and perhaps Representative Lean as well and Mr. Fuller. And from that list, perhaps make a suggestion or two. I'd be happy to do that.
Thank you. Appreciate that. Yeah, send it to Mr. Fuller. That'd be very helpful.
Okay, I will do that.
All right. Any other agencies? Is Ms. Cass from prosecuting attorneys, is she on Zoom? Ms. Callis? No? No, okay. Anyone else on Zoom for this topic? In the room, please come forward.
My name is Rachel Hayes. I'm representing the Wyoming Coalition for Animal Protection. Mr. Chairman, members of the committee, thank you for the opportunity to speak today. We understand this committee's focus is standardizing penalties across offenses, and we support that. Animal cruelty is currently penalized less consistently than comparable offenses in Title VI. Our recommendations aim to close that gap and are as follows. First, close the repeat offender gap. A second animal cruelty conviction under 6.3.1004 stays a misdemeanor today. The fine rises, but jail time stays capped at 6 months. Wyoming's domestic violence statute already escalates repeat offenses to a felony. We're asking you to apply that same standard and to consider raising the felony fine cap so the penalty can better reflect harm in cases like multi-animal neglect. Second, recognize the connection between domestic violence and violence toward animals. Studies show 50 to 75% of female domestic violence survivors with pets report their abuser threatened, harmed, or killed those animals. We're asking that a domestic violence conviction count as a prior offense for sentencing in a later animal cruelty case and vice versa. These are often the same behavior aimed at different victims, and Wyoming's sentencing structure should reflect that. Third, turning back to animal cruelty sentencing, require a mental health evaluation directly in the statute. Courts already have general authority to order this for any offense, but Wyoming just took a more direct approach this session. The new grooming statute requires by name that a convicted offender complete a treatment program, no discretion involved. We're asking for the same structure here. Fourth, strengthen the post-conviction ownership ban. Wyoming courts can already order a ban on future ownership, but it's entirely optional, even after a felony or repeat conviction. And there's no way for a shelter or breeder to know a ban exists before a sale. We're asking for 3 changes. Make it mandatory for felonies and repeats. Specify a penalty for violating it, and make that information checkable. The materials before you lay out 3 ways to do that. We urge the committee's support in moving these changes forward. Thank you.
Thank you, Ms. Haynes, is that right?
Hayes.
Hayes. Thank
And
you
is
for, thank you so much for being here this morning. Questions? Okay, appreciate you being here. Thank you so much.
Thank you.
Anyone else testify this morning? Come up, please. You might need to turn that middle one off. It's still on. There we go. All right, we're good. Mr. Itzen.
Dan Hitson, the district attorney of Natrona County. Members of the committee, there's two areas that I think we need to discuss. One's the mandatory minimums. Those are the worst crimes that I think are probably on the books, right? When we talk the worst of the worst, this is probably that group. Yesterday, you had a whole group of victims sitting behind me. I talked about death and loss and those things. This is what we're talking about here. There needs to be mandatory minimums for those. In essence, what we're proposing to do is take tools out of the tool bag to use. We use a term today of judicial flexibility, I've heard. Well, okay, I guess. I'm not sure what that exactly means. But with all these mandatory minimums and aggravated robbery, we have that flexibility. When we talk about negotiated dispositions, a prosecutor can go to the defense and say, plead guilty to robbery, i.e. I'm getting you off the mandatory minimum, you plead cold. The judge has all the flexibility up to the maximum of the statute. But when we start taking away the mandatory minimums, we start taking that tool away from us. When we start talking about habitual criminals, and we had a conversation in the hallway about this. Oftentimes there are two habitual criminals. We call it the small habitual and the big habitual. Oftentimes some prosecutors in the small habitual say, okay, I won't charge you with this enhancement, this mandatory minimum. You walk off and plead guilty. What is happening there, ladies and gentlemen, is a quick resolution with guaranteed results for those victims. We're giving them certainty. When we start taking the tools out of the tool bag, they start to lose certainty. And frankly, when we start talking about kidnapping people and not releasing them, first and second degree sexual assault, repeated sexual assaults, aggravated robberies, aggravated blackmails, human trafficking. Ladies and gentlemen, those are the people that have earned a mandatory minimum at the least. There is no flexibility. The second point that I would like to address is the look back period for domestic violence. Every October is Domestic Violence Awareness Month. In Natrona County, they have a candlelight vigil on the first Sunday. And families of domestic violence survivors come, and their loved ones who have died are recognized. I've spoke at that gathering a number of times. And oftentimes I give the same speech. Nobody listens. If I have drugs when I'm 18 years old and I get busted, and then I have drugs when I'm 20, I get busted. And then when I have drugs when I'm 50 and I get busted, that's a felony. But if I beat my wife when I'm 18 years old, and then I beat my wife again when I'm 20, and then I'm 50 and I do it, well, that's just a misdemeanor. That's okay. When we start talking about human life and protection of that human life, there can't be a look back period. Those convictions drop off. Even if we successfully prosecute domestic violence people, send them to the pen, the likelihood of one of their priors dropping off is very high. So when they come back, they can beat her up again. It's just a misdemeanor. Those two things seem very incongruent to me. How you can have drugs as a kid, and I can look back and go, okay, by God, now you're a felon. But if you beat your wife and you time it right, you'll beat a felony altogether. In our state, at one point, a large majority of our homicides came from domestic violence. You want to see haunting facts and photos. Go look at one of those, sit in a trial. These are people that said they love each other, and now somebody shot in the back of the head. The look back period for domestic violence makes absolutely no sense. Ladies and gentlemen, I would stand for questions.
Committee, any questions for DA? It's Representative Chesty.
Thank you, Mr. Chairman. A very quick question on the mandatory minimums. We heard some testimony earlier from Ms. Bennett from the Public Defender's Office about how for the minor crimes that the mandatory minimums don't make a lot of sense. And she gave us a great example, I thought, of the one mandatory minimum that my subcommittee recommended getting rid of was defrauding the drug and alcohol screening test second offense. That's a 7-day mandatory minimum that we're recommending we dispose of. And the example she gave, I thought, was a good example of distinguishing between a habitual drunk and somebody who's just trying to get to work because they have to feed their family. By removing that mandatory minimum, don't we give the judge some flexibility to deal with a very different situation? So would you agree that the mandatory minimums in the low-level offenses possibly don't make any sense?
Mr. Ritson.
Mr. Chairman, Representative Chesnick. No, sir, I don't agree. When we talk about flexibility, flexibility starts with the charging decision. Simply because it's your second time defrauding a urine test doesn't necessarily mean I have to charge it as your second time. We've invested great powers within a prosecutor to use. And I would like to tell you, and I know probably everyone has a different story, but I think the prosecutor uses that. I'm troubled with your example to some degree also. If a fellow's going to work, but he has to defraud his UA in order to do that, I guess my point as a prosecutor and a citizen of Wyoming is maybe he should stop using drugs and alcohol and start providing for his family. Just because there's a mandatory minimum, if I choose to charge a second offense, there's a reason for that. And I think we rely upon that prosecutor's discretion. Prosecutors aren't looking to go get everybody, right? And maximum sentences and those things. That's not true. Our job is probably one of the hardest jobs. And the Supreme Court tells us, quote unquote, is to do justice. That's hard in cases. One, and sometimes it's very unattainable. But those victims that sat there, they necessarily don't understand that either, because justice to them is you can't give somebody enough penalty when their mom dies. That's part of what we balance as a prosecutor, right? That, can we change behavior? Where do we go from here? Messaging to the public. So if there's an individual who's walking to work but drinks every night and he screws up his UA twice, I'm not sure that's the bandit of the county, sir, that we're looking to go get. Thank you.
Follow up.
Thank you, Mr. Chairman. So you're saying that prosecutors have discretion, which I agree with. I think it's useful. I think that's necessary. And this bill does not change that at all. But you're saying that if the prosecutor has discretion, the judge should not. Why wouldn't the judge have an opportunity to have some discretion as well as the prosecution?
Mr. Ritson.
Mr. Chairman, Representative Chesnick. Mandatory minimums do not take away judges' discretions. They put a floor into a decision. A judge can give dead minimum, 20 to 25, for example. A judge has discretion, but I think the biggest part is it's the state of Wyoming who brings those charges. state of Wyoming who makes the charging decisions. And how that plays from there, the court has discretion. And even our case law, sir, if a court would like to, and I agree with DA Hackle and Ms. Bennett, a court can't suspend a mandatory minimum, and there's case law on it. The Wyoming Supreme Court has said that's acceptable. Is it happening all the time? Absolutely not. But there is that discretion there.
Representative Kelly? Nope. Got it. Representative Lane?
Thank you, Mr. Chairman. Thank you for joining us today, Mr. Itzen. Would you agree that plea deals already allow for us to individualize sentencing while allowing for uniformity of law to be applied?
Mr. Itzen?
Mr. Chairman, Representative Lane. When you look at it, making an offer as a prosecutor, negotiated disposition, you have to look at the facts of the case. Every case turns up on its own. So yes, you look at the individual case, you look at the individual person, you look at criminal history, you look at harm to the community, and you put those together. So yes, absolutely, you have a sense of individualized sentencing in cases. So yeah, I would agree.
Okay. Thank you for being here this morning, Mr. Itzen. Anyone else wishing to testify on Title VI?
I'm not sure if this is the time for me to.
Please come forward.
Thanks.
No time like the present.
Thank you very much.
So just so everyone knows, it's coming up on 10:15. We're scheduled till 11:30 on this topic, so we still have ample time to hear public testimony. But I do want to save some time for the committee to actually work through the bill. So keep your comments on point and tell us what you'd like us to hear. You've got the green light, so introduce yourself and begin.
Thank you, Mr. Chairman. Good morning, Mr. Chairman, members of the committee. And before I start, I want to thank you all for your service. I know that you're paid very little, not enough, and I appreciate the time that you donate to the state of Wyoming. Thank you. My name is Mark Corbett, and I'm the Executive Director of Compassion Wyoming, a 501c3 registered with the state of Wyoming and the IRS, with a board of directors and volunteers. We are financially supported by private philanthropic churches as well as public donations. I'd like to give you our mission statement, which is brief so you understand what our agenda is. Compassion Wyoming is rooted in the Christian principles of mercy and redemption. We work to facilitate safe and successful reentry for inmates who've demonstrated genuine change. We believe that rehabilitation is possible, that data-driven policies reduce prison overcrowding, and that the public understanding, grounded in facts, not fear, creates a stronger and safer Wyoming. Our mission is to change public perspectives through honest communication, historical data, and compassionate advocacy, helping long-term inmates pursue a better future with dignity and purpose. That's our mission statement. Wyoming has a problem. The problem is a growing population of inmates with life sentences and virtual life sentences. A virtual life sentence is a sentence of 50 years or longer. The lifers and virtual lifers have no meaningful avenue for release once they've served decades and demonstrated change. I gave some charts to the LSO, and I hope you have them before you if you want to refer them. Chart number 1, in 2005, Wyoming had 193 lifers and virtual lifers. Today, we have at least 320, a 65% increase in just 20 years. From 1895 to 1995, our forefathers utilized commutations in a highly effective way by reducing long sentences of inmates who had demonstrated change. This successful policy was all but discontinued without a replacement, which has resulted in a dramatic increase of the number of lifers and virtual lifers being warehoused until death. Chart number 2. This is a chart that shows the Wyoming governor since 1950s, the number of commutations each one of them signed, and the corresponding prison population that they had. This chart shows, if you see the yellow highlight, Governor Sullivan signed 218 commutations over 8 years, which plummeted to just 3 commutations signed by Governor Meade. Without commutations, there's currently no exit strategy in Wyoming for long-term inmates who've demonstrated change. I need to explain something. That doesn't mean that 218 inmates were released. When they sign commutations, especially for long-term offenders, they'll take somebody like from a life sentence to a 90, then they'll wait a few years, 90 to an 80, 80 to a 70. It might take 5 or 6 commutations to release somebody. And many times the governor's not releasing him at all during his term. He's just reducing that sentence. And many of those commutations were for nonviolent offenses. But the ultimate decider is still going to be the parole board. The governors, as a rule, it's very, very rare that they'll give a commutation and put somebody directly on the streets. It's still the parole board, 7 other individuals that have to make a decision, and it's many years down the road. But commutations offer a way for people that have demonstrated change to have hope and to continue with their positive behavior and eventually possibly get out. And we've eliminated the possibly in the state of Wyoming. Chart number 3, individuals who are released after serving long sentences rarely commit new crimes. Contrary to what the media would have you believe in Hollywood, the facts are long-termers just don't reoffend. On common law, a nonprofit, I shouldn't say don't reoffend, but have a low risk. On common law, a nonprofit in California advocates for the release of lifers. They have successfully supported the release of 337 lifers, of which 99% have remained out of prison. Which is not on your chart is that of those 99% that have stayed out, 100% are housed and 52% are doing community service. The national average for a citizen is 25%. So they're actively involved in their communities. Of the 860 murderers paroled between 1990 and 2010, the Stanford tract, only 5 inmates committed new crimes and none of them were convicted of murder. The average released lifer is in his mid-50s. Experts say older ex-cons are less prone to new crimes than younger ones. Between 1999 and 2003, New York released 368 convicted murderers on parole. Of those, only 6, or 1.6%, returned within 3 years with a new felony, none for a violent offense. These are pretty good stats. And if the rest of the population, inmate population in Wyoming, had that type of recidivism rate, we wouldn't have very many prisons in Wyoming. These are safe people to release. And I'm not advocating, we are not advocating that we open the doors and release all the long-termers or all the murderers. You still have a parole board, you still have a system in place. But what we'd like is a release mechanism to get some of them out, the ones that have demonstrated genuine change, and we've lost that release mechanism. We had it for the first 100 years. Chart number 4. Older individuals rarely commit new crimes. In Virginia, only 1.3% of ex-offenders over 55 committed new crimes and were reincarcerated. According to New York's most recently available report on recidivism on age, those released after age 65 returned for a new commitment rate of just 1%, back to that 99% success rate. So the long-term offenders and the elderly just don't come back. Wyoming's aging population is growing. If you'll look at chart number 4, you'll see there's a graph on there that shows that in 1997, Wyoming inmates that were age 50 or older were just 6% of the inmate population. By 2024, that increased to 24%. We now have a warehouse of the elderly. The prison system was never designed to become a nursing home, and that's what's becoming. We have geriatric wards. There's not even enough room to put everybody in. And these are the ones that are safest to release, and these are the ones we're excelling and keeping. And it isn't just Wyoming. I'm not singling Wyoming now. It's a national problem. So why should this matter to the Judicial Committee? Fiscal responsibility. Elderly incarceration is expensive, especially medical. It costs about $49,000 a year to keep an inmate. Somebody that serves 40 years, $2 million. And when you're talking about the 320 that are lifers and virtual lifers. Many of them are going to serve 30 or 40 years. And it's a growing population. If you do the math, 320 at 40 years, you're talking over $500 million. And that's real money, money that we spend on schools, spend on roads. And if we have a low-risk population, I'm asking for consideration to look at what we can do with these people. Wyoming, other states have passed or are looking at prosecutorial review or inmates applying to the sentencing court after a period of time for a review for a sentence reduction. And we're not talking about a few years. I think Louisiana recently passed a law after 25 years. So we're talking about some people doing some time. They're older. We can see by the last 30 years, if you look at the commutations graph, that we can't leave this issue up to just the executive branch. It doesn't work. They're not doing it. And the problem is the population is growing. And even if our next governor should prove to be one that signs commutations, there's no guarantee that the governor after is. And that's a big ask to put it all on just the executive branch. My request today, my ask today is that Wyoming consider a meaningful review or release mechanism for long-serving inmates, and I emphasize demonstrated rehabilitation. And there are ways, and we have Director Shannon behind me. They can see it. They can follow in the disciplinary record. They can see if they're getting in trouble in prison. They can see if they're going to groups. They can see if they're making a genuine change. And the statistics, whether it's the elderly or whether it's the murderers, show this is a group that is safe to release. And again, I'm not advocating we open up doors for everyone. And I stand for questions.
Committee, any questions? Mr. Corbett. Representative Lee.
Thank you, Mr. Chairman. Thank you for joining us today. I just have a question. When you're asking us to consider releasing the older population, because we have geriatric wards there, what does that look like when it comes out into the public sector? These folks haven't had an opportunity to prepare for retirement. What does the financial burden look like to the public sector at that point?
I'm glad you asked that question, Representative Lena. And I've been asked that question many times.
Mr. Corbett, always.
Thank you.
Chairman. Thank you.
Thank you. Thank you, Representative Walker. Representative, or Chairman Washington, may I answer that question? Thank you. I'm glad that Representative Lean asked that question, Chairman Washington. The facts are California released 860, and they didn't have any problem where they were being housed or where they went. You're looking at someone who did 41 years. And when I came out, I went to work in a coal mine, and I'm still working in a coal mine as well as doing this. And people can be successful. And the other thing is we can, the burden doesn't have to be carried just by the state of Wyoming. When you release the elderly, Medicare picks up and some of these other finances that the state does not have access to. And we have Director Shannon behind me that could also probably address some of that.
Thank you. Further questions? All right. Thank you, Mr. Corbett.
You bet.
Sir.
Chairman Washit, Chairman Olson, members of the Joint Judiciary Committee. My name is Dan Fetzko, and I am an attorney, and I'm a professor of criminal justice at the University of Wyoming. I recently had a book published a couple of months ago that features Mr. Corbett. It's called Cutting Life Short, published by the University of Wyoming Press and the University of Colorado Press. And to give you a little bit of information on my background, I was a public defender for a few years. I was a county prosecutor for a couple of years. I spent 5 years at the Attorney General's office, where I was the attorney for the Department of Corrections. Then I spent 10 years at the Wyoming Parole Board. 3 of those years I was the executive director. That's where I came to know Mr. Corbett when he was in prison. And I like to tell a lot of people I went through like kind of the Shawshank Redemption effect when I worked at the Parole Board, and that I saw men and women who had been serving decades in prison, and that entire time they'd been working on transforming themselves, rehabilitating themselves, but they couldn't get out of prison because of the political winds. As Mr. Corbett said, commutations just dried up. they vanished. And when I was at the parole board, there was a set of incarcerated people who were still there who were expecting those commutations. And it was very devastating to listen to them kind of wrap their head around the reality that it just wasn't coming, that those had gone away. And it wasn't just Wyoming, as Mr. Corbett mentioned, it was all across the country. And there's a variety of factors that led to these life sentences growing in the US. But to give you an example, in 1972, there were only 200,000 people in prison in the entire country. Now there are 200,000 people in this country doing life. Like, we incarcerate 10 to 20 times as many people for life than the rest of the world. And as Mr. Corbett mentioned, it's not just Wyoming. I think the life sentence population has increased in the US by 600% since the early 1970s. And from my viewpoint at the parole board, there were many, many people, again, who I felt were deserving of some kind of release. A few people that I profile in my book, they got out because of the courts. Miller v. Alabama in 2012 declared that it's cruel and unusual to incarcerate a juvenile for life without any chance of parole. So I've seen some individuals who've been released under that mechanism, and they're out there, and I'll tell you, they're doing fantastic, contributing to their community. In one case, I know an individual who got his welding certificate in the Department of Corrections. He's now making 6 figures in Texas. And he contacted me to ask how he could get off of parole. And I told him, unfortunately, you have lifetime parole supervision in Wyoming. There's really no mechanism to get rid of that unless they change the policy or they change the statute. But I'm seeing these individuals, Mr. Corbett is another example, who are being released from these long sentences, and they're thriving in the community. So that's one of the reasons that I wrote the book. It really impacted me, my days at the parole board. And now that I teach at the university, I have that that ability, I guess, to write about these things. And I would tell you, and I guess something I didn't realize until I was at the parole board, but that our state constitution, as you probably all know, the penal system is supposed to be based on the principles of reformation, which is rehabilitation, right? And I feel that, as Mr. Corbett has mentioned, that the hope for any chance of release for some of the people who are serving time in our prison is very minimal right now. And I don't feel that it lines up with the principles of our Constitution. So, and I do want to point out that I'm here individually or on behalf of Compassion Wyoming, that I don't speak on behalf of the University of Wyoming. But if I were going to make one recommendation to this committee, would be to maybe study second look laws as a potential interim topic. There are now, I think, 25 states in the United States who have either adopted or looked at various second look law mechanisms. Like, for instance, in California, there was a very famous second look case that came up, you've probably heard of, the Menendez brothers. Both of those men were serving 2 life sentences in prison without the possibility of parole. But under the California law, they were resentenced. And the victims in those cases, and I don't want to forget the victim in these discussions. I don't know if Mr. Corbett mentioned this, but his victim is a former state legislator, Steve Watt, who for many years advocated to get Mr. Corbett out of prison. Several other individuals that I profile in my book are victims of violent crime who have seen the person who harmed them reform themselves in prison, and either want that person to get out or went through a restorative justice dialogue where they supported that person's release. So that's one of the things I kind of want to make clear to the committee, is that any process that I would recommend, I would like to have, of course, victim input from the courts, from the prosecutors, and maybe a second look 20, 25 years down the road. But with that, I will end my comments. I'd stand for any questions. And again, I appreciate your time.
Thank you. Questions? So this is one of those topics that's probably beyond the scope of our Title VI penalty review. But perhaps one of the members of the committee will pick up the bill topic as an individual bill for a second look law for the next session. But I appreciate you both being here today. Thank you.
Thanks. Can I say Mr. Chairman?
No.
Nope. Okay, thank you.
One bite of the apple. Yeah, all right.
Thanks.
Thank you very much, committee members.
Thank you for your time.
Anyone else in the room wishing to testify on Title VI penalty review? Anybody on Zoom? Nobody? Okay, so I'm going to close public comment. This will be a fairly time-consuming process, I suspect, as the committee tries to work through many different options on Title VI.
Move the 800-page bill. No, I'm just kidding, Mr. Co-Chairman. So, Mr. Co-Chairman, you and I briefly talked about this and you alluded to it to the committee earlier, but I think committee, something I've been thinking about is I think the best way to approach this is to create compartments that are similar in nature rather than have one really big bill that if there's opposition in the legislature to a particular part of the bill, we could lose the whole bill and end up with nothing. You know, and these can be broken down into, for example, the misdemeanors, 1,750 the misdemeanors can literally be a bill by itself. Mandatory minimums, if there's appetite for that, which there may not be based on earlier discussion, but if there is, that could be a bill by itself rather than let that get tied up with, you know, the misdemeanor conversation. I think we should separate them out. And I think for our purposes of our discussion, that's probably the best way to discuss it too, is to go through these by category and decide where the appetite is for the committee. So I guess what my recommendation, Mr. Co-Chairman, would be to the committee members is to make, if there's a particular area that we've discussed that you want to see advanced, then I think you should make a motion to create a bill draft on that topic area. And then we can, you know, then we can tackle that piece of the pie and then go to another one and another one. And then hopefully we've addressed everything that the two committees have created by doing that. But I just think, Mr. Co-Chairman, that's probably the easiest way to approach this.
Thank you, Mr. Co-Chairman. I concur with that. I just asked the two chairmen if as we go through this, there's a sense that we've missed something, that maybe an important topic hasn't fit into one of the boxes that we create, that you call that to our attention so we can think about that. Okay. So for the boxes, I'm thinking about the misdemeanors, the felony standardization where we were talking about 3 years and 5 years and kind of getting those organized a little differently. You had a kind of a number of 7-year felonies and some of those sorts of things. So I think the felony standardization could be a box. Mandatory minimums, we can have a discussion. The first degree murder, language change, the domestic violence look back, the reckless language, whether that fits within the penalty discussion, I'm not sure, but it seems relevant to some of the conversations that we've had. So either the chairman, another box that you might suggest, anything, Representative Chestic?
Thank you, Mr. Chairman. I'd suggest the box on the animal cruelty issues too. There's some good, we got some good information today, which I have to look at and study some more, but I would suggest maybe a bill draft dealing with animal cruelty penalties.
Okay. Representative Ling?
Thank you, Mr. Chairman. I'd recommend a box for anything to do with the sexual assault statutes or sexually related offenses.
Okay, let's see how we work through this. We'll start with the misdemeanor discussion.
Yeah, Mr. Chairman.
Mr. Co-Chairman.
I have a motion on that topic.
Motion, please.
So I would make a motion for a bill draft that moves all of our misdemeanors from $750 to $1,000. So I know that's not what the subcommittee came out with. It's the opposite of what the subcommittee came out with. But I think it makes a lot more sense. And based on testimony, I think there's some community buy-in on that as well. So that would be my motion.
So second by Senator Crum. So the motion is create a bill draft that would increase the fines on misdemeanors from 750 to a maximum 1,000.
Up to, yeah.
And
Mr. Fuller.
yes, Mr. Chairman, just to clarify, given the discussion is only Title VI, that the motion pertains only to those misdemeanors in Title VI.
Yeah, what was studied.
Yes, Title VI.
All right, thank you, Mr. Chairman.
Representative Krim. Representative Chestic.
Thank you, Mr. Chairman. Could I suggest, between 750 and 1,000, I don't have a strong feeling, but I do think that as long as we're dealing with misdemeanors in one bill, maybe we ought to also include in that bill draft the reduction from 1 year to 6 months for those identified in working group for the odd chapters. Add that reduction down to 6 months for those misdemeanors that the committee felt was appropriate. And it can be done in the same bill draft.
To the sponsor.
I'm just looking at the memo real quick to see what we're talking about. So we're on page 3, right, of your report. And there's a list here of you're moving these from 1 year down to 6 months. Everything on this list, it would be your recommendation?
Representative Chestic, is that correct?
Yes, that is correct.
Yeah, I guess for discussion purposes, I'm okay with that, and we'll see how the committee feels about it, but I don't have a strong feeling against it.
Okay, so are we clear on the motion? We've got a second. The second agree to the motion? Changes? All right. Discussion. Discussion. Representative Senator Craigo.
Thank you, Mr. Chairman. So I'm concerned about adding the amendment to the fine bill. I mean, I think you're going to run into some pretty strong headwinds lowering the penalty for a few of these. The imprisonment or jail time, I should say, because we're talking about 6 months versus a year, it'd be in county. You know, for example, accepting kickbacks could be a bad one. Contraband into a correctional facility, that also could be something we want to put someone in jail for longer than 6 months. Some of them, I don't necessarily disagree, but there's a few of them on the list that if we include all those, I think we're going to run into some issues when we're trying to pass the bill, which we knew this was going to be a problem when we started. I mean, I guess from my perspective, I'd rather us do the fines. And if we want to bring a bill to cover this, to cover the second part of the amendment, the proposed amendment by Representative Chestic, let's do that. I don't think it hurts to have 7 or 8 bills rather than 4, if, you know, or 5 or whatever the number is. I'd rather us pass something. I just think we're going to run into some issues when we start doing that. Thank you, Mr. Chairman.
Senator Cole.
I'll let Senator Crum go first, if that's all right, Mr. Chairman. Is that okay?
Senator Crum.
Yeah, Mr. Chairman, after listening to Senator Craigo, I think he's right, and I'd like to withdraw my second.
All right, Mr. Co-Chairman, my Senate committee is running over me now, so I'm going to have to back up
All right.
that as well.
So we're going to stay with the motion dealing with just the fine.
Got out
on
in front of my
misdemeanor.
skis a little
So
bit.
this
too
bill
much there.
motion is just the fines, just the fines. Now I know how the Senate works. It's a different organization over there. All right, so.
Mr.
back
Chairman,
on
we're a
just the fine.
grassroots organization over here.
All right, the fine, 750 to 1,000. Any further discussion? Saying none. Let's see, all in favor, so this is ask for, do we need a roll call for a bill draft?
To sponsor the bill. Oh, this is a bill draft.
This is a bill draft.
I'm trying to.
I know you're trying to expedite
I'm
things.
trying to do everything I can to not have another meeting, Mr. Co-Chairman.
All right, all in favor of the motion to move misdemeanor fines from 750 to 1,000 to standardize that. All in favor, say aye. Aye. Those opposed, no. All right, so we'll get a bill draft, 750 to 1,000. Representative Chestic.
Yes, Mr. Chairman, thank you. I'd like to also request a bill draft to, on page 3 of the on group report take all of those misdemeanors from 1 year down to 6 months. I understand that some of them may be controversial. We can deal with those when we deal with that bill draft, but I would like to see that bill draft.
Is there a second?
I'll second.
Second by Representative Lean, Representative Singh. Bleh. Tongue-tied today. All right, so we have a motion and a second. Discussion? Representative Shestak?
Thank you, Mr. Chairman. Again, this is a recommendation we talked about in the working group extensively. There was a broad consensus on doing this, mostly because it relates to the bill that the bill draft, the bill we agreed to sponsor, which it allows for probation up to a full year for any misdemeanor. That frees us up to reduce these penalties because, to be honest, most of these misdemeanors are never dealt with in prison sentences anyway, or incarceration. So I simply wish to honor the work of the working group.
Further discussion? Seeing none? All in favor of the motion for a bill draft on the reduction of incarceration from 1 year to 6 months on the listed crimes, say aye.
Aye.
Those opposed, no. It's close, but I think it failed. Further motions on misdemeanors. Have we covered misdemeanors? Okay. Felony penalty standardization. Representative Chestik, your committee recommended several changes there on felony penalties.
Yes, Mr. Chairman. These would appear on, starting on page 4 of 5, the big bullet point towards the end is to increase, basically abolish the 2-year felony and make them all 3-year felonies with a fine of $5,000. Also, that would include the group on page 6 or on page 5, where some of the 3-year penalties, 3-year felonies had fines of $3,000. Want to increase those to $5,000 to be consistent. So I would move those 2 bullet points as a bill draft.
Is there a second?
Second.
Second by Representative Singh. Ms. Fuller, you clear on what the motion is? Okay, discussion? Senator Craigo.
Mr. Chairman, could we just, could Representative Chestik tell us exactly what the motion is again, just so we're all on the same page? Sorry.
Representative Chestik. So we're on page 4 and 5 of your recommendation, right?
Yes, of the committee recommendations, starting on page 4, the big bullet point towards the bottom, amend the maximum penalties for felonies that currently provide 2-year maximum to make it a maximum of 3 years and a maximum fine of $5,000, which is in most cases an increase from the penalties of $2,000. So that's the first bullet point. And the other bullet point that I think needs to be in this bill is on page 5. Increase the fine amounts for felony offenses that currently specify a maximum 3-year. Those that currently have a $3,000 penalty should go up to $5,000 to be consistent with the other felonies.
So we're moving all the 2-year felonies to 3-year felonies and then making sure the fines are all $5,000 for all the 3-year felonies. Everybody clear? All in favor of Representative Chestik's motion, say aye.
Aye.
Those opposed, no. That's a passed motion for the bill draft. Take up mandatory minimums, the box of mandatory minimums. Do we have a motion? Do we have a motion? All right. No motion on mandatory minimums. The first degree murder language changing from according to law to referencing the specific statute. You have a motion on that?
So moved.
So moved by Senator Crago, second by Representative Lean. Discussion? Discussion? All right, all in favor of creating a bill draft, change the language on first degree murder from according to law to referencing the statute, say aye. Those opposed, no. Okay, that passes. The box dealing with sexual assault and sex offenses, Representative Lean.
Thank you, Mr. Chairman. I was trying to think of the way to word this to make it the cleanest.
You can start conceptually and we can
So
fine tune it as
I
we
move
go.
a bill draft to clean up the imprisonment penalties for 62705, 62706, 62 or 64303. And I would just reference what the work that was done with the group to make those from 3 years to 15 years, 5 years to 25 years, 12 years to 15 years, and 12 years to 30 years. Just for the committee's discussion purposes, whether we leave it in or out of the bill draft, there was a recommendation to change it from victim's spouse to victim's intimate partner on 62303. This was second degree sexual assault between, it currently says victim's spouse. There was a conversation about to modernize the language and make it the victim's intimate partner. I would add that just for committee discussion. 62303 A, I, and IV.
Mr. Fuller, you
yeah.
good on that?
Mr. Chairman, and this will,
Help us if you can.
I think this will help clarify, hopefully for everyone. I take the motion to be the last bullet point on page 3. And then the 4 bullet points on page 4 as the motion.
Thank you, Mr. Fuller.
Senator Crago.
I don't know if we have a second. Did we get a second yet? We did have it. Okay, question, Mr. Chairman, was what about the second to last bullet point on page 3, which also deals with sexual assault? Is that part of the motion or not?
Mr. Fuller, Representative Lean.
I would be happy to add it to the motion with the first degree and second degree sexual assault. I think this one's going to determine a little bit more conversation, the decrease from life to 100 years.
Follow up, Mr. Chairman?
Senator Crago.
Yeah, I'm not asking it to be included. I was just curious if it was the intent of the bringer of the motion to include it or not. And if not, that's fine. Just so we are all know what's going on. Thank you, Mr. Chairman.
Representative Lean.
At this time, I would leave that aside and let somebody amend it if they'd like to.
Okay. So the motion deals with the last bullet point on page 3 of Representative Lean's memo and the 4 bullet points on page 4. Everybody clear on what we're talking about here?
Mr. Co-Chairman, yeah, I want to have at least some conversation about the last bullet point. Going from the language victim's spouse to victim's intimate partner, that may require a definition of intimate partner. I don't know if we use that elsewhere in statute, but that could mean, it could mean a former spouse, it could mean a spouse, it could mean people that live together. It could only mean people that engage in sexual relations together, even if they don't live together. There's just it could mean a lot of different things. And I don't know if there was discussion on the committee about that. If we just need a definition, I'm fine with that. I don't know what the definition necessarily would need to be, or if it's already somewhere in statute, Mr. Fuller.
Yep. Mr. Chairman, Chairman Olson, as far as I know, that term, I could not find it used in statute. And so it follows there is not a definition of that term either. I think it would be up to the committee to decide if that term should be defined or if it's left to where a court would have to basically interpret its plain language and applying that.
If we put it in the bill draft, can we deal with that when we have the bill draft? My only concern would be if we wanted to make that a standalone bill, we're down to our last meeting. So
No, I think it could be included in this bill draft.
any
And Mr. Chairman, I could, in drafting the bill, include, see if there are definitions from other states or at least in a staff comment, offer items for the committee to consider in that regard.
Let's do that.
Let's do that, yeah. Okay, everybody clear on the motion? The bill draft dealing with these bullet points, page 3 and 4. Everybody clear on what we're voting on? All in favor of bill draft, say aye.
Aye.
Those opposed, no. All right, so we'll have a bill draft dealing with sexual assault, sexual offenses. The domestic violence look back. Representative Lee.
Yes, Mr. Chairman, I would like to move that we have a bill draft for 62511B, I and III, and we strike the look back periods to allow for maximum protection of people in Wyoming against physical abuse.
Is there a second? Second by Representative Singh. Discussion? Everybody clear on the look back? All in favor of this bill draft, say aye.
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 All opposed, no? Okay, that one carries. We'll get a bill draft on domestic violence looking back. Then we have, what was that? There's a group of the ones with skiing and I'm not sure which group had that.
I think that was the misdemeanor.
Is that included in the misdemeanors or not?
I think it's in that report.
Yeah, it's on page 2 of Representative Chestic's report. Offenses of trespass on a closed or ski area, offense of impaired skiing, defrauding a drug or alcohol screening test, and subsequent offense of trespassing unlawfully to collect resource data. Sir, any consideration on those topics? Representative Chestic.
Thank you, Mr. Chairman. I was going to make a proposal. We have a bill draft. Those are kind of a miscellaneous group of topics, all fairly non-controversial, unrelated to each other, just didn't fit in any other category. So I would make a motion to have a bill draft dealing with the 4 bullet points on page 2 of the odd group report.
Everybody clear? Is there a second? Representative Singh. Discussion? Mr. Fuller, is it doable, put these 4 kind of diverse topics into one bill draft?
Mr. Chairman, I could probably craft a bill and when we discuss this, should the motion pass in October, I'll highlight the bill title, how that's framed for the committee's consideration.
Everybody good? All in favor of this bill draft, say aye. Aye.
Aye.
Those opposed, no. Think that carries. We'll have a bill draft on skiing and unrelated offenses. Any other boxes I'm missing here? Representative Chestic?
Thank you, Mr. Chairman. I have 2 things. Number one, I wasn't quite prepared. There's a couple, we did have a bill draft on felony standardizations. There's a couple of things on page 5 that ought to be included in that I did not refer to earlier. I'd like to have those included in the prior bill draft. Basically, the last 3 bullet points also deal with fines, increasing fines for felony offenses. And they all, I think, do relate to the prior bill draft. So I would like to add those to the prior bill draft.
So the motion is to add these to the bill draft dealing with felony standardization. Is there a second to add? Representative Singh? Discussion, everybody clear? Kind of an oversight. We missed those last three bullet points on page 5. This motion would add those to the original bill draft. All those in favor say aye.
Aye.
Any opposed? No. All right, that one carries. I'll be added to the bill draft. Representative Chestic.
And the last one, I do want to address the animal cruelty issue that has been brought up today. And I'm not quite sure how to do that because I'm not prepared with specifics yet. I guess, could I have permission from the committee to work with LSO and the animal cruelty organization to come up with a bill draft that we can then bring back to the October meeting, dealing with trying to equalize some of those penalties?
How would that be based on this handout that the animal
Basically, yes.
cruelty? So the motion is for a bill draft roughly based on the handout from the Animal Cruelty Coalition. Is there a second to that motion? Is there a second? I'm not seeing a second. Okay, sorry, motion fails. Any further? Any further boxes? Representative Lean?
Mr. Chairman, just for committee's discussion, I'd like to discuss the reckless and recklessly removal from sorry, I've got too many notes here now. It's on page 3, 62704 and 62706. And Ms. Hackle's research did go out to the committee. I know you haven't necessarily had time to review it. The purpose of asking for the bill draft is just to keep it on our radar so that we can review that material and revisit it in the next meeting.
Okay, do you have a second to the motion on reckless? Second by Representative Brady. Discussion? Representative Chestic.
Thank you, Mr. Chairman. I think I'm going to vote no on this one only because this doesn't really deal with the topic of equalization. It's not getting to the penalties, and that was a task of this task force. In our working group, we had a couple of situations like this where people on the committee said, well, this crime itself, the elements are weird. We have to fix the elements of the crime. And I said, no, that's beyond the scope of our committee. So let's not do that. I would recommend that this is the same situation with the recklessness standard. I would recommend that be handled as an individual bill rather than a committee bill, because I don't think it was within the scope of what we were talking about during our working groups.
Further discussion? Yeah, I think I concur with Representative Chestic. Size up of that, maybe it'd be better. But let's vote on the motion for a bill draft. All those in favor say aye. All those opposed, no. That one fails. Any other boxes I missed? Working group chairman? Representative Lean?
Thank you, Mr. Chairman. I'm not sure which box this one necessarily falls into. It is on page 3 of the even group, and it's 66102A, and it's to remove the reference of violence actions for the person that's committing this offense. What we found in that working group was that this stood to remove somebody's firearm rights, and it may fall also under a personal bill now that I'm saying this to you, because it doesn't necessarily affect how the penalties are being
You're
issued.
withdrawing your motion?
Withdrawn. Sorry.
All right. So with that committee, it's 11 o'clock. good work. I don't know how many bill drafts we ended up with.
Ask how many bill drafts is that?
6 new bill drafts, Mr.
Six
Chairman.
new bill drafts. Piece of cake. We'll work those through in October. No guarantee that all of those will move forward, but we can take a look at them in October and decide which are topics that we want to move forward. With that, let's take a short break, maybe 7 minutes till 11:07. We'll come back for the state public defender. So the next item on our agenda is the presentation by the Wyoming State Office of Public Defender to give us an update. After this update, we're going to break for lunch a little early and then jump back into public access to the courts, guardianship task force, Wyoming probate code, and those two remaining traffic law enforcement issues that we have left over from yesterday. So with that, Ms. Bennett, welcome.
Thank you, Mr. Chairman. Patricia Bennett, State Public Defender, and I am joined by Mr. David Corman, the Deputy State Public Defender. I appreciate you putting me on the agenda for today. I'd like to start with just a brief overview. I was appointed to the position as of April 1st. When I was appointed, we had 4 or 5 open positions in Campbell County, which I know this committee is well aware of the recruiting issues and retention issues we've had in that district. We had openings in Cheyenne, and we had a few expected openings throughout the state as far as retirements and that sort of thing. As of now, I have just made a job offer for the last position in Cheyenne, which is extremely helpful. That I'd like to talk for just a second about that office specifically, and just an overview of the caseload in that district over the last 5 years has increased exponentially. In Cheyenne, in 5 years ago, there were roughly 1,000 misdemeanor cases. When I did the caseload numbers for this last fiscal year, there were 2,500. So if that gives the committee some idea of the increase in caseload in that district. To address that, what I have done is I moved one of the open positions from Campbell County down to Laramie County to be able to address that. I believe those case numbers are going to even out a bit with that additional position. I will lose a contractor. That contractor is expected to take that full-time position, so I'll probably need another contractor in Cheyenne. But I think Cheyenne is going to be okay for the foreseeable future as far as caseload maximums. And I know this committee's been educated a few times on public defender caseload maximums. What that looks like is a single attorney can manage 150 felony cases, 400 misdemeanor cases, or 200 juvenile cases. And that is an or in there. Typically, most of our offices, our attorneys handle a mixture of those cases. And we have a formula that we use for figuring out whether those offices have, and I don't do individual attorneys. We do that per office to see where those offices are as far as caseload maximums. And that is the maximum number of cases that a person can manage and still remain effective and still meet their licensing obligations. So we had 3 offices over the last fiscal year that were over 100% of caseload maximums. One was Campbell County, and I'm going to talk specifically about Campbell County. One was Natrona County and also Laramie County. I think Laramie County will be okay. I'd like to get another contractor in there, but I think they're okay for now with the movement of that position. I have spoken somewhat with Ms. Hackle, and she and I are both concerned. Should data centers and the remote or the rumors, I guess, or talk about adding a man camp and that sort of thing in Laramie County. If that happens, we are going to be asking for additional positions. It just stands to reason that if we have a large influx of workers in a man camp, we're going to have an increase in appointments to us. So that is something that may be happening in the future, but right now we're okay in Laramie County. The biggest concern has been for several years, Campbell County. Our Campbell County office also covers Crook and Weston counties. When I began this position, I think we had 4 or 5 open positions up there. I've made some personnel changes there. We currently have 3 open positions in Campbell County, so we're making some positive progress up there. We are going to do something a little bit creative in Campbell County. What the plan is we are going to split off the caseload for Crook and Weston County. And I have an attorney who actually lives in Cheyenne, but I believe I'm going to be able to fill that position for that person to work in a partial remote status and be able to cover Crook and Weston counties. What that does is not only take that caseload away from the folks that are in Gillette specifically, but it prevents the people in Gillette from having to travel. The travel in almost all of my offices adds a tremendous amount of time to our caseloads. So we do have offices, Johnson County is one, that area, that are below that 100% caseload maximum, but they drive. And they are on the road a considerable amount of time. The best example of that is our Douglas office. They cover 4 different counties. They cover Goshen, Platte, Converse, and all of those counties. So they are on the road all the time. So that's kind of where we are personnel-wise. We are working very hard with the university to increase our recruiting efforts, but we are losing attorneys. We're losing them to Colorado. I've lost attorneys to Montana, to Alaska, to other places. A lot of that has to do with compensation. And we absolutely appreciate the efforts of the legislature in increasing our salaries. I think that's going to help some. I am going to end with an ask, but what we are also doing to help ourselves is we are contracting with a marketing company. It is the same company that does the, we've all seen the ads for the Governor's Council on Impaired Driving all over the state. We are also going to be working with that company once we get that contract in place. They are going to help us produce a video and also a placard, a paper type product, some sort of card that we can use for reaching out to law schools beyond Wyoming's borders, because we are finding that Wyoming College of Law is graduating fewer attorneys. A lot of those attorneys are going to other places. They come to Wyoming. Wyoming has a wonderful clinical program. They also have a great money value for law school. So what we're seeing is that we have a lot of out-of-state lawyers that come in, they go to law school here, and then they go back home. And that is stymieing some of our recruiting and retention efforts, mostly our recruiting efforts. But we are going to be working a lot more closely with the law school, working closely with the Defender Aid Program to try to bring in some of these new attorneys. So that is where we were, kind of where we are right now. My ask for this committee is I would ask this committee to sponsor a bill that is similar to the bill or the legislation that's already in place for medical professionals. That specific bill is, or not a bill, I'm sorry, it's a statute, is 92118 and 119. What that law does is it provides for some student loan reimbursement for medical professionals that agree to provide medical services for a certain amount of time in rural areas in Wyoming. I'm asking this committee to sponsor a bill to offer something similar to lawyers that agree to work for the Public Defender's Office. I very crudely kind of took that legislation and turned it into what I would like it to look like for public defenders. And what it does is it provides 2 different avenues for student loan reimbursement. The first one is if an attorney is willing to spend 3 years in an underserved area, then they would be eligible for $30,000 of student loan reimbursement for a year, per year. And that number came from the statute for medical professionals. And I think I want to be careful and not say rural areas, because for whatever reason, I'm not really sure why, I don't typically have a hard time finding lawyers to take jobs in those rural areas. I can fill a position in Torrington, but I can't fill a position in Gillette. I'm not sure why that is because there's a smaller pool, but that I'd like it to be underserved areas rather than rural areas because I don't have trouble filling the rural area positions. But I'd also like to be able to offer something for our attorneys that have been with our office, have been committed to our office, and they are kind of that mid-career, they've been with us a while, they've made that commitment. I'd like to offer a smaller amount for them, but a longer commitment period. So for brand new attorneys, 3 years, $30,000, you go where I tell you to go, which currently that would be Gillette and Sheridan. If someone wants to be in Laramie, they want to be in Cheyenne, they want to be somewhere else, it would be a smaller amount. And the amount that I drafted was $20,000 for that, but with a 5-year commitment to the public defender's office. And then allow the public defender to draft rules to do a couple of things. Number one, I think there should be a cap. It's not $30,000 a year forever. It would be either $100,000 total cap for the career of that attorney, or I think I also toyed with $150,000 because of the 5-year period. But something along that lines, the one for medical professionals, I wasn't able to find that there's a cap in that statute, but I think that that's appropriate. But I think that that would allow us to add some incentive to a total package to be able to attract and keep lawyers in this state. There are other states that do this. I don't have specifics. I know that New York has one, Nebraska has one. There's probably a handful of states that have some type of student loan reimbursement. But I'm asking this committee to sponsor a bill that would offer essentially the same type of reimbursement to lawyers, to public defenders specifically, that is offered to medical professionals. And with that, I would stand for questions.
Ms. Bennett, thank you for being here. You know, a couple of years ago, the Wyoming State Bar brought a proposal for rural lawyers, but they were talking about lawyers in private practice primarily. Didn't have great success for a number of reasons, but I think your suggestion of a program might have some merit. I'm not sure the committee can take up another committee bill at this juncture. Will of the committee will dictate that, but typically our bill topics are set by management council in April. So,
Well, Mr. Co-Chairman,
Mr. Co-Chairman.
definitely the will of the committee, but this does fit within our management council directive because we have agency reports. And so agencies, the various agencies come to us. This is how we got like Department of Corrections bill, for example. So I would say it fits within in what our directive is.
Okay. So we may be able to, we'll see what the committee wants to do, but we may be able to create a bill draft for our next meeting. Difficulty is we only got one more meeting. So, but good topics. And I think the potential of being able to not only recruit new lawyers into the public defender's office, but also retain your existing lawyers. I can see the merits of kind of combining both. But if there is a motion for a bill draft, we might need you to help chime in a little bit on the language of what exactly we're trying to get there.
Mr. Chairman, may I add just a couple of other points to that?
Ms. Bennett.
Thank you, sir. When we look at cost, and I know that there's always a cost to that, and that's what makes some of these things so difficult. I've thought about some different ways to pay for that. I am loath to ask for another fee imposed on people that use the court system, whether that's criminal defendants or civil civil litigants, but I would maybe ask, annually, the Public Defender's Office brings in between $500,000 and $600,000 in public defender fees. Those go into the general fund. So I would ask that maybe in order to help pay for this type of legislation, that a portion of those, maybe $500,000 of public defender fees could be used, something along those lines. But I think the retention of a lawyer is incredibly important and is cost effective in the long run. Mr. Corman ran some quick numbers. If currently in Campbell County, the Public Defender's Office is unavailable for misdemeanors. We are trying to start slowly taking some of those misdemeanor cases, but the fee to assign a private lawyer to take a misdemeanor case is $150 an hour. If last year there were 478 cases assigned to private lawyers at a cost that is covered by the Public Defender's Office under their budget. So I believe that if I can retain lawyers and recruit lawyers into that office, that it's going to be a cost savings overall. $1,000 for a misdemeanor case, it doesn't take very long with 478 cases to come up with the amount of money that we would be asking for to be able to provide some student loan reimbursement if we can do that and retain lawyers up there.
Okay. Mr. Co-Chairman?
Thank you, Mr. Co-Chairman. I was just going to ask, because my memory is a little fuzzy on the medical reimbursement statute. Does that statute require that those seeking reimbursement go through the WWAMI program and so they're essentially they go to the University of Washington, but they are in conjunction with University of Wyoming graduates? Doesn't it require that they go through that program, or?
Mr. Chairman, Mr. Co-Chairman, I believe that it does require that, yes.
So then, just as a follow-up, have you considered that with your proposal, the requirement that they be University of Wyoming graduates to receive the reimbursement? So, I mean, to me, that would be very analogous to what we've done in the past. And if not, why should it be different?
Ms. Bennett?
Mr. Chairman, Mr. Co-Chairman, I would love to have a program specific to the University of Wyoming and recruit our people and keep our people here. But given the numbers of lawyers that are graduating from the University of Wyoming and are subsequently being licensed, I think that in order for this to be effective and for us to really be able to get our numbers where they need to be, I think that we need to cast a wider net. And I don't want to punish lawyers that want to come to us from other law schools, and I don't want to punish lawyers that have already graduated from other law schools and work for us now. So as much, maybe there's a way to write in an additional incentive for University of Wyoming graduates, but I don't want to exclude people from other states that want to come and work with us.
Okay. Senator Cole.
Yeah, thank you, Mr. Chairman. Just a general question. You brought up the amount of fees that are brought in to the state, goes back in the general fund. What is the budgetary cost for your division for the state of Wyoming?
Ms. Bennett?
Mr. Chairman, Senator Kolb, and I am going to be shooting in the dark because I don't have that number specifically, but I want to say my budget's in 50 million or so overall for the entire.
Mr. Chairman, 50 million you said, ma'am?
Roughly.
Approximately. I'm not going to hold you to it. I just wanted general numbers. Thank you.
Because of all the numbers that I brought with me, that was not the one.
Okay. Representative Shestak.
Thank you, Mr. Chairman, and thank you for this suggestion, Ms. Bennett. Do you have any, and this might be another number you don't have at the top of your head, but how much money do you spend currently on outside counsel, the $150 an hour for private counsel? What is your annual budget for that right now?
Ms. Bennett.
Thank you, Mr. Chairman. Representative Chestick, that number comes out of our contract, our budget, it's not our, it's our 900 series money. I would have to go back and look and get that specific number over the last year. I know that the unavailability in Campbell County has been in place since April, a year ago, so just over a year. So I would have to get you that specific number, but I can certainly provide you with that.
Representative Kriegel.
Thank you, Mr. Chairman. So just a quick question, Ms. Bennett, on how we compare to other states for our PD employees, for the lawyers. What's our average salary for our lawyers on staff? And then what do we pay our contract lawyers roughly? Give us an idea on that. And then how do we compare to lawyers, other lawyers in the criminal justice system, prosecutors, lawyers in the Attorney General's office, et cetera?
Ms. Bennett.
Mr. Chairman, Senator Craigo, with the new 2024 numbers, what I will tell you is my numbers and Ms. Hackle's numbers and Mr. Itzon's numbers, we're all state employees. The issue comes in when we're dealing with prosecutors' offices in other places because they are county employees. It's a difficult comparison because Campbell County is a county that typically can pay their lawyers a lot more. Albany County cannot pay their prosecutors quite as much as we do. So it's difficult to give you a specific answer to that question. But what I will tell you is I have lost count of the number of attorneys that have left my office to go work for the Campbell County attorney. It is a little bit frustrating, but it's really county specific. I think that the AG's office, the Natrona County and Laramie County DA's offices we're all on the same pay scale. But otherwise we are competing with counties.
Thank you, Mr. Chairman. So what's the average number, just so we know what we're sort of talking about? What's the average salary for one of your employees?
So, I apologize, sir. Chairman Washut, our MPP, which is the midpoint for an attorney, practicing attorney one, is $76.70 per month. That is a big increase from what it was a year ago. Our attorney fours, the MPP is $10,398.26. We try very hard to keep our attorneys between 90% and the MPP because we have to be competitive. Before we got this pay raise, anecdotally, one of the people that I lost to Montana as a brand new graduating attorney was offered $88,000 in one of those public defender offices. So we couldn't even come close. But now that we have had the pay raises, I think salary rise, we're a little bit closer, but still we are behind some other places like Colorado.
Thank you.
Mr. Co-Chairman.
Mr. Co-Chairman.
Just to answer Senator Kolb's question earlier, I went and looked at your budget. Your biennial budget is 30 million and some change. That's for 2 years. So 15 million per year is the budget for the public defender's office. With 26 million of the 30 million state general funds. And then there's some county revenues that go into there, and that's about 4.5 million in county revenues. So hopefully that helps, Senator Kolb.
Senator Crum.
Thank you, Mr. Chairman. Looking at it a little bit differently, what's I'm probably using the wrong terminology, but what's the success rate of the public defender's office on getting charges dropped against their clients compared to other states that surround us? Do we know the percentage of I'm going to say percentage of wins versus our states around us, how it compares?
Ms. Bennett.
Mr. Chairman, Senator Crum, I don't know, I guess with other states, I don't have those numbers. I will tell you that And I can give you how we compare to private practice attorneys. Having been a private practice attorney, I can tell you that when you're in private practice, number one, you have considerably fewer cases. You also have to run a business. You have to worry about whether the phone rings, and you are very much worried about what your bottom line is because you have people to pay. My attorneys do nothing but criminal defense. All they have to do is defend their clients. We have a very high success rate throughout the state as far as winning trials. I am convinced that simply the experience of my attorneys, because that is all they do, that we have the best defense attorneys in the state because they have more cases under their belt, more practice. And so I would say compared to private practice, which is not really an answer to your question, but it's the best I can do, that we have some of the very best trial attorneys in the state and appellate attorneys as well.
Mr. Chairman, just a quick follow-up. Not to create a lot of work or anything like that, but it would be interesting to see if there's some statistic out there that available that you could look at and see if something like that exists. It may not exist, and I'm not asking for one to be created, but if there's one that exists, it'd be interesting to see it. Thank you, Mr. Chairman.
Ms. Bennett, if you can find some of those numbers and maybe just email them over to Mr. Fuller, we'll share with the committee. All right, well, we kicking up on time, so Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. I have a question about your comment on the data centers in Laramie County with the man camps. Currently, I know that there's proposed data centers in Uintah County, Natrona-Converse counties, Fremont counties. So what does this look like as an influx for large industrial projects for your office moving forward with these projects coming in across the state, not just necessarily in Laramie County?
Ms. Bennett.
Mr. Chairman, Representative Lean, thank you for that question. It's very different in the different counties. I have 10 lawyers in Cheyenne. I have 2 lawyers in Uintah County. And 1 half-time contractor there. So it would be a big burden for those smaller offices. We see Cheyenne Frontier Days comes in every year and we have an uptick in cases. So I can only imagine, you know, the 10 days of Frontier Days gives us an uptick, what months and months and months of those workers being in these small communities is going to do. So I do have concerns. My concerns really are in keeping the lawyers I have in that office, that they don't get overwhelmed and decide that private practice would be easier, because sometimes it is. So if those things happen, and that's an if for down the road, then we are going to have to address whether or not the number of lawyers I have in those offices is going to be adequate, because I have some big concerns they may not.
Representative Webb.
Thank you, Mr. Chairman, and mine is the same with Uintah County. Has anybody reached out? Are you aware of the proposed man camp in Uintah County?
Ms. Bennett.
Thank you, Mr. Chairman. Representative Webb, I don't have specifics other than what I read in the newspaper. So I don't have any specifics on that or the numbers that we expect as far as workers or just the influx of, I guess, population that's going to affect. So I don't have anything specific.
Thank you. And
Follow up?
you're aware now.
All right. Thank you very much. We appreciate the update. We have another question from Senator Kolb.
Yeah, thank you, Mr. Chairman. Just a statistical question about the number of workers, I think, to get kind of an idea about the impact. So I know in Sweetwater, we've had very large projects and the public defender folks are very busy over there. And I wonder if you could track it with the number of employees to a project, because we've had real large ones come in, power plant, scrubbers, I don't know, 500-600 workers. So I wondered if you'd have some data. So instead of just saying, well, there's a data center coming in and we know there's going to be more folks we're going to probably need, but to have some numbers that say, in the past, this is what's happened and this is the impacts, like for like projects, say construction workers. I just wonder maybe you could come up with some information to justify a need because of the large influx of construction workers. Thank you, Mr. Chairman.
Ms. Bennett, if you can find those numbers, looking back at some of our other major developments, maybe see what the impacts were historically.
Representative Washington, what I can do is historically, I have the ability to run our case numbers from this date to this date. So while it would be inexact, what I can probably do is look back at, during these dates, we had an influx of this many people. I can give you the case numbers before and after that and maybe be able to come up with, probably wouldn't be anything exact, but I could definitely come up with an estimate.
Mr. Co-Chairman.
Yeah, Mr. Co-Chairman, sorry. I just have to chime in a little bit before this spins too out of control because I do represent Laramie County and there are 10 operational data centers in Laramie County already. So we have a pretty good idea if we looked at that data over the last few years, we would have a really good idea of the impact of 10 data centers. There are 5 under construction and 9 new proposed. So I just want to preface that in your minds that it's not like there's no data centers in Cheyenne and we're wondering what will happen with these man caps. That there's 10 large data centers already in Laramie County. So we have a pretty good idea of what it does. So I just wanted to get some facts out there before that spins out of control.
Very good. All right.
Mr.
Thank
Chairman,
you.
can I just address Senator Olson quickly?
Sure.
I think when I started, I talked about the number of misdemeanor cases over the last 5 years that have gone from just barely over 1,000 to over 2,500 over the last 5 years. So I think that might answer some of that question.
Thank you very much. All right. Are we going to get a motion on rural attorneys from my co-chairman? No?
I think, I'm at odds, honestly, with what the public defender's office is requesting. I tried to throw a softball to her, but she threw it back down. If I were to see this type of program, I would want to see it for University of Wyoming graduates. We already have a model for that in the medical and dental world, and we know what it looks like. I'm uncomfortable with a general model. So I don't think I'm on the same page with the public defenders. And I also think this idea has come to the committee before. I also think that maybe addressing the supplemental budget might be a better solution for the public defender's office in this up and coming session, that we could appropriate more money to the public defender's office if that's what's necessary. I'm not seeing the same vision with this program. I think, again, if the committee had interest in tying this to the University of Wyoming, then I would, but I'd love to hear what the rest of the committee thinks.
Senator Kriegel.
Thank you, Mr. Chairman. So I too was on the committee when we dealt with the rural attorney program, or the proposal for that a few years ago. I think it was in 2023. And the reason we brought that is because there is a shortage of lawyers everywhere. I mean, I told the committee back then that when I moved to Johnson County, we had 15 practicing lawyers. And we are now down to literally there's 3 of us in town. And one of the lawyers is a contract lawyer for the PD's office. And so this is a problem everywhere, not just in the public defender's office. I think we need to figure out a way to get them the additional funds they need so that we can hire and retain folks in that particular office, because it's very important that we do that. But I also probably won't support a bill draft that only does it for the public defender's office. So if we're going to do some sort of college program, I think it has to be bigger than that. It has to be one that helps address the issue across all spectrums of the legal profession. And so that's where I am, but I'll be standing, I'll be backing them up if we go ask for additional funds so that we can get the lawyers we need where we need them, for sure. we need to be competitive. We need to offer those competitive wages to our employees in the public defender's office. And so I'm probably with the co-chairman on that I'd be interested in moving it forward under certain circumstances, but I just as proposed, I'm not interested in that. So hopefully we can figure out a way to get them the help they need. Thanks, Mr. Chairman.
Thank you. It does concern me that maybe by bringing in out-of-state students to fill slots available at the University of Wyoming Law School, that if we're denying Wyoming students some of those slots, maybe our ability to retain those students in Wyoming might be affected, so maybe we have to have the dean come to our meeting in October. I'll talk to him. But thank you so much for being here this morning, Mr. Corman.
Thank you.
All right, with that, members, we're going to.
Oh, Mr. Chairman.
Representative Chestic.
I'll go there. I will actually like to make a motion for a bill draft to kind of resurrect the program we had, the rural lawyer program from a couple of years ago. I would like to resurrect that, have a bill draft to consider, but also making sure that the bill draft does include some, I'm not sure how to do it, but some encouragement that public service is not just aimed at private lawyers, but also allowing for public service lawyers, public defenders lawyers. We fold that into the bill draft. So I'd like to make that motion.
Is there a second?
Discussion.
Second for Representative Crago. Discussion. Representative Chestic, do you want to add more since it's your motion?
No, I thought that we had a good discussion. The Bar Association was all on board with it last time around. And I think it failed by one vote or something. It was a very close vote in the committee. So we got pretty far with the project a couple years ago. And in light of what we've learned from Ms. Bennett right now, the problem extends not just to civil lawyers, but also to public service lawyers. I think the time has come to readdress the issue, and I'd like to see a bill draft and continue the conversation.
Mr. Chairman, I don't have a whole lot to add. I mean, I think if we are going to do this, I don't mind actually putting some sort of emphasis on our public employee attorneys. I don't know how we do that in the bill draft, but I think that's the first thing we need to address. I mean, we can use that template we had built before, but problem is we only have one meeting left. And so it's going to be difficult. If we're able to, we can all start looking at that. I'm sure Mr. Fuller can send us the draft, after the meeting's over later this week or whatever, send us that draft bill that we had before, and we can start looking at that and bring our suggestions for amendments and share that with the public defender's office prior to the next meeting. But I think it wouldn't hurt to look at it again.
Thank you, Mr. Chairman. Just a question, and forgive my ignorance here, but what committee sponsored that bill previously? Was it the Judiciary Committee or was it?
Came to Judiciary, we voted not to sponsor it.
Okay, all right, thank you.
All right. Senator Kolb.
Yeah, thank you, Mr. Chairman. Just a brief comment. It's too big of a lift and it's too late. Even if I was to agree, I don't think we could work on the details and then bring another draft bill out of this committee. I think if we're going to address this, we should probably handle it similar that we do the physician program with the WWAMI program. There's a lot to it. So the concept, I think maybe is an interim topic, but I think for a bill coming out of this committee, it's too big and too late. Thank you, Mr. Chairman.
All right, with that, all in favor of the motion, you all know we're trying to bring back the bill draft from the 2023 Rural Lawyer Initiative. All in favor, say aye. Aye. Those opposed, no. No. That motion has failed. Okay, members, it's 11:50. We'll take 90 minutes for lunch. So we need to be back here at